Yeah, 1 of 2021 is filed for condonation of delay of 140 days in filing LR application to bring LRs of deceased. Sole appellant, huh?
Sole appellant.
This is the appellant. Prove that affidavit for the reason stated in the accompanying affidavit. Delay of 140 days in filing an LR application is controlled. IA 1 of 2021 is allowed. Consequently, IA 2 of 2021 is allowed. Abatement is set aside. IA 3 of 2021 is allowed. LRs of deceased appellant is permitted to come on record. Learned counsel for the appellant is permitted to amend the constitution.
Number 22, Deepika Keshav, Y. Hariprasad for appellant, MP Ramesh.
Filing a paper. Yes.
That was dismissed for default on 1511.
Hmm.
Then they was restored on cost.
Last occasion it is.
Yes,
This
this
what on the-
is the case. 1 week, 2 weeks, you also time have done. This is a small issue. What has been paid?
Let us see that order. 2 weeks time is granted to file a paper book on 15/11/2023. Have you filed it? No, last occasion only I have ordered.
This is small issue.
Then I will dismiss it. You have not complied my order. No, cost, it is not that for a cost. See, you have not paid the, file the paper book, even last occasion also. 5/1/2024. That is what that order. When will you file? I will fix the date within that time. If you have not paid,
LCR has already come.
yes. Finally, 2 weeks time is granted to file a paper book. If paper book is not filed, the appeal will be dismissed. Appeal may be dismissed as default without reference to the court. Yes. Yes, interim order granted earlier is extended till next date of hearing. Yes, now that without reference to the court, it will dismiss. Then it has to be posted before me for recalling. Then we will see that. Yes, this is last occasion, madam. Yes. Now this is how. This is one of the method to get interim orders to be continued. Not one this case. So many cases I have get it dismissed, recalled, interim order extended. No, not in your case. In all cases, this is the things. This is the one of the method to get it interim order continued. Yes.
Number 23, Manjunath Prasad V for appellant, N. Shivakumar.
Certificate got supplied by the Lord. To kindly grant 2 weeks.
I'm filing a paper book. Finally, 2 weeks time is granted to file a paper book.
Number 24, P. Raju for appellant, K. Raghavendra.
2 weeks time finally, madam.
Finally, 2 weeks time is granted to file a paper book.
Grateful.
Number 25, Vivek Kolla for appellant, connected matter, Suresh C. Deshpande.
Weeks. At the request, 2 weeks time is granted. File a paper book. Connected matter only? It is arising out of the same judgment and degree. One paper book is enough. You file it first one. Let us see other. Yes.
Number 26, Prasanna BR for appellant.
Yeah, the unclaimed then.
6 claim.
R1, Srinivasamurthy. Claim 10%. B. Lingegowda.
6.
It's Ani Textile Processing and New Timber Layout. Sir. K. Shiva Prasad. Not claimed, return to sender.
Yes, notice issued to respondent number 1 and 6, written with postal stamp, claim in service of notice to R1 and R6 is said sufficient. Inariga process of yes, week's time is granted to the process to issue notice to unserved respondent.
Number 27 adjourned. Number 28, Kanchan Srinivasan, petition for appellant. Number 28.
Sorry.
Number 29, Ajit K. Shetty for appellant, K. Narayana.
Using of year, correct address, appeal memo, appeal to issue notice to us. Password.
Number 30, Lokesh K. Vijay Kumar for appellant, Naveen Kumar K. N.
Finally, 4 weeks time is granted to file a paper book for the request.
Number 31, Narayana Swamy PM for appellant.
Reminder is there. No, that is not the reprimand. They have been directed. That is, if it is subject to the result of the appeal. Yes.
Number 31, Narayana Swamy PM, Namante Gowda.
The request week's time is granted to do the needful.
Number 32, Deshpande Amitanand for appellant. Number 32,
Also,
number 33, Yan Surya Narayana for appellant, Mohan MS.
where is that appellant? Non-compliance of the office objection. IA 1 and 2 ಏನದು?
Carrying the order dated.
ಆಫೀಸ್ ಸರ್ವ್ ಮಾಡಿದಾರಾ? Permanent counsel for the respondent ಅದೊಂದೇ ಆಫೀಸ್ objection. Appellant has served a copy. Its office objection is overruled. Yes.
Number 34, Mahesh PJ for appellant, CH-10.
First 2 weeks time is granted to do the needful.
Number 35, Arshad Joshi for appellant.
Request week's time is granted to do the needful.
Number 36, Naveed Ahmad for appellant.
Week's time is granted to do the needful.
Number 37, Hanumantaraya D for appellant.
Yes. What is that maintainability? Maintainability, that's said.
Office objection, maintainability.
Huh?
Not treated. Here section 96. The suit was dismissed. The objection which was raised by the registry before the court below. Already last occasion your lordship. Kindly your lordship take page number 25 of my appeal. Of the judgment of honorable appellate court in
Where? Oh, that. Oh, yes.
Versus Gram Panchayat Village.
Now that law has been reversed now. Yes, Mr. Matter has to go back. This is recent judgment on Supreme Court.
Yes, yes, sir.
Where is that? You got it. Even that plaintiff claim file in a suit for adverse position.
Already basic people.
ಮೊನ್ನೆ ಮತ್ತೊಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಬಂದಿದೆ.
ಇನ್ನೇ ಬಂದಿರೋದಿಲ್ಲ ಸರ್.
ಎಲ್ಲಿದೆ ಜಡ್ಜ್ಮೆಂಟ್ ನಿಮ್ದು? Yes, I will allow and send it back, Mr. Government. Government is the only party.
Yes, sir.
Therefore, today I said it is for that purpose only.
Yes, sir.
What is that office objection?
Office objection, the R sheet is not visible on the.
Is it to be made good as per the section 49 during the complaints council for the appellant has filed an OS valuation slip on verification of the same. Office has raised the following objection: proof of any certificate copies document to verify specific value of the appeal memo, relief declaration. What is that valuation you have done?
50 rupees. We paid 50 rupees on the plane before the court below.
Yes, Mr. Government Advocate. Why that government is a party? You are seeking adverse position against
Yes,
the
sir.
government.
From 1969, we are put up in the possession and we are taken.
No, that will be decided by the trial. Only on that.
We have the review of the law on adverse position with the honorable.
What is the judgment? Tell you. Recent.
Again, such adverse position, possessing owner cannot only seek to protect his right as a defendant in his suit, to file a suit for declaration of permanent injunction, restraining defendant from interfering with his possession, where owner whose titles to extinguish or any other.
ಅಲ್ಲ ಇದ್ರಲ್ಲೇ ತಾನೆ ಇದ್ರದ್ದು ಜಡ್ಜ್ಮೆಂಟ್ ರಿವರ್ಸ್ ಮಾಡಿ
ಹೌದು.
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಜಡ್ಜ್ಮೆಂಟ್ ರಿವರ್ಸ್ ಮಾಡಿರೋದೆಲ್ಲ ಇದ್ರಿ
ಅಲ್ಲ adverse position could only protect his title as a defendant in a suit, but could not file a suit for declaration of his title.
Earlier judgment
overruled.
ಹೇಳಿದಾರಾ ಎಲ್ಲಿದೆ action restraining or seeking disposition ruling of the Supreme Court. Yes. Right. Submission of learned counsel for the appellant. Effect of office objection is accepted. Office objection is overruled. Government advocate is directed to take notice. Even though it is posted for orders. Matter has been heard finally. This appeal is filed by plaintiff challenging updated judgment dated 30th/8/2018. FR number ಅಲ್ಲೇ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. Asked by which court, Mr. Principal Senior Civil Judge, Bangalore. FR number 1267 of 2018. Whereby suit filed by the plaintiff is dismissed as not maintainable. Huh? Yes, yes. Plaintiff has filed suit for declaration based on the adverse position against the government of Karnataka and other government department. The registry has raised an objection before the trial court regarding mentality of the suit. Trial court, relying on judgment of apex court in Gurudwara Sahib versus Grama Panchayat village Sirtala and another, 2014-1 SCC 669. Following the judgment, dismissed that suit as not maintainable, being agreed by the same. The plaintiff has filed this appeal. The judgment referred by the apex court in Gurudwara Sahib has been overruled by apex court in subsequent judgment 2019-8 SCC 729 as held as follows. As held, such a adverse position as possessory owner can not only seek to protect his title as a defendant in the suit. Really, did not do the mark ಮಾಡಿದ್ದೀನಿ ಅದನ್ನ extract ಮಾಡಿ. In view of the above, order passed by the trial court liable to be set aside, matter required to be remitted back to the trial court for reconsideration in accordance with law. Accordingly, the appeal is allowed. Judgment order dated. Judgment order dated 30th/8/2018, passed by so and so court in FR number 1267 of 2018 is set aside. The matter is remitted back to the trial court. The direction to reconsider that matter afresh in accordance with it. All the contentions of the parties are left open.
DCF ಅಂತ ಇನ್ನೊಂದು ಕೋರ್ಟ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್. Number 38, Nayanatara Bhusri for appellant, Ravindra Prasad G.
I appear for the petitioner, my lord. Request kindly that your lordship may kindly grant us a week to present the paper book, my lord.
Yes, finally, 2 weeks time is granted to file a paper.
A date may be given, my lord.
Yes, 2 weeks.
1 week is fine, my lord.
You do it even within
Yes.
2 days also. Maximum time
One-
limit has been given. Yes,
1 week will be fine, my lord.
yes.
Bill number 39, C. Shankar Reddy for appellant.
Discrepancy in the plaintiff share value at CC valuation slip 35,000. Share is said. What is this, Mr.?
For the defendant before the trial. Additional slip your lordship put at page 35.
Yes.
Total value of the property was shown as 35,40,000. Lordship can find in page 36.
Yes.
Plaintiff share value was shown as 11,80,000. Not, therefore, when the matter was supposed to be filed before the district court, they have returned saying that we do not have jurisdiction. Therefore, I find the present appeal before us. Of this honorable court not has raised objection, saying that this honorable court does not have a pecuniary jurisdiction. Therefore, in detail, not in the appeal memorandum.
Now, why this court is not having pecuniary jurisdiction?
The subjection that has been.
Now, 35,40,000 is what is the share of the plaintiff? 1/4 share of the ಎಷ್ಟು ಬರುತ್ತೆ? 35 ಲಕ್ಷ. ಕರೆಕ್ಟ್ ಇದೆಯಾ ಅದು ಅಂತ ಕೇಳ್ತಾ ಇರೋದು. ಬರುತ್ತೆ 35 ಎಷ್ಟು ಬರುತ್ತೆ?
75,000.
ಆದ್ರೆ ಇಬ್ರು ಡಿಫೆಂಡೆಂಟ್ಸ್ ಅಪೀಲ್ ಆಗ್ತಾ ಇರೋದು.
Each individual ಅದು combine ಅಲ್ಲ. I think individually they have to be collected or
ಪ್ಲೇಂಟಿಫ್ ಒಂದು ಶೇರ್ಗೆ ಎಷ್ಟು ಅಂತ ತೋರಿಸ್ತಾರೆ. ಇಲ್ಲಿ ಇಬ್ರು ಡಿಫೆಂಡೆಂಟ್ಸ್ ಅಪೀಲ್ ಆಗ್ತಾ ಇದೆ.
no, it is not that a case of the defendant. It is the case of the share of the plaintiff is for a determination.
ಲಾಜಿಕ್ ಪಾಲ್ಯ ಆಗ್ತದೆ. ಅವ್ರು FR ನಂಬರ್ ರಿಟರ್ನ್
That you challenge. That you challenge filing in a writ petition. No, what is the law? Law is that share of the plaintiff for calculation of the suit court fee, not that defendant this thing. Because you are challenging the degree. No.
Only the plaintiff should not be dismissed. And if plaintiff is appealing before this honorable court, not that would be correct. According to me, subject to correction. Because the two sharers are challenging On the very same ground, the regular.
Show me
appeal.
that any judgment, because you are challenging the judgment and degree passed in favor of the plaintiff. We are questioning and verifying that share which is collected to the plaintiff. To that extent only court fee has to be paid. Not that you show me that judgment that it has to be considered on the basis of that defendant.
Even otherwise, as lordship should not evaluation unless push the embers or
Our course the our court fee.
on the basis of what is indicated in the valuation slip.
See, we are not here to accept what the party said. You are the defendant. You are not objected before the trial court. This is nothing but a bench hunting to see that it should be more than 10 lakhs. ಯಾದಕ್ ಬರ್ಲಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅಂತ ಸೀನಿಯರ್ ಸಿವಿಲ್ ಜಡ್ಜಿ ಬರ್ಲಿ ಅಂತ ಅವ್ರು ಹಾಕಿರ್ತಾರೆ. You should have objected there. 5 lakhs. Their calculation is wrong. You should have objected that. Then even assuming that for that senior civil judge, this will not make any difference. Whether it's an 11 lakhs, 10 lakhs. Now we have to be calculated on the basis of that. Whatever that plaintiff has given, wrong calculation can be considered.
Accepted by the court. 11 lakhs 80,000 is the plaintiff share value. It has been accepted.
No,
Because of that particular issue only, when RA came to be filed before the district court, court has decided we do not have peculiar jurisdiction and presented before the high court.
Yes. Now that 1/4 share is to be, we have to be determined total amount to 1/4 share. ಅವ್ರು ಏನೋ ತಪ್ಪು ಮಾಡಿದ್ದಾರೆ ಅಂತ ಬಿಟ್ಟು we have to accept it. See, High Court has calculated, it said that value is 3,85,000.
As for the valuations, they are showing 11 lakhs.
That is wrong. If they show wrong, I have to accept what that even wrong also. We are here to correct it. That should be your argument before the district court, saying that this is the value. Court is not for to, accept that what the party said.
It make this submission. Your lordship may make an observation. This court does not have peculiar jurisdiction. And I may be convicted. Jurisdictional court.
Yes.
It has 8,50,000. I have got no objection.
Yes. Office has raised an objection on the mentality, stating that the total value of the property has been calculated as 35 lakhs 40,000. Share of the plaintiff is 1/4 comes to 8,85,000. Hence, appeal is not maintainable before this court. Even though in the valuation slip, share of the plaintiff has been shown as 11,80,000. But plaintiff share is only a 1/4. Therefore, office has rightly calculated it 8,85,000. Hence, the appeal filed by appellant before this court is not maintainable. Liberty is reserved, hence dismissed as not maintainable, reserving liberty to the appellant to approach appropriate legal form. You want return? Yes. Office is directed to return that certified copies of the judgment and degree that appellant forthwith.
Issue arises.
Therefore, you file a memo for return that this thing instead of all these things. No. You file a memo for, yes, learned counsel for the appellant has filed a memo.
And appeal memorandum to be presented before the jurisdictional court.
Yes. ಇದೇ ತರ ಹಾಕ ಇದರಲ್ಲಿ since office has raised an objection ಹೇಳಿದ್ನಲ್ಲ, it's a therefore he has filed a memo return of the papers to present before appropriate legal forum. Memo is taken on record. The paper is returned to appellant to represent before that appropriate legal forum within 4 weeks from the date of returning the paper.
Matter, Kiralamba Party, Vaidya Narayana Sharma for appellant, connected matter, emergency.
I will see that is that any parties are representing in that first appeal. Then same advocate will be directed to take notice.
Serial number 40.
First appeal, you are appearing for response. Yes.
In that, we can't appear for R2. They have to take fresh steps. So far as paper book is concerned, it is common judgment. So one is filed already, that is sufficient. So far as notice to R2 is concerned, they have to take it because we are not appearing. We are contesting actually against each other. R2, they have to take notice in the other two matter.
No. I will come to that. Now that in your appeal,
Yes.
service is complete. We will come to
I
that
am
second.
appearing. Yes, it's complete.
Second matter, notice to R1 and R2. Who is R1?
R1 I am appearing. R1
Yes.
I am appearing. In both the matters,
Okay.
R1 I am appearing.
You are taking notice.
Yes. R1 is,
Yes.
I can take notice.
Yes,
Because
that's
same
what-
party, same
yes.
party. Not to R2.
YK Narayan Sharma is directed, is undertaken to appear for respondent number 1, connected matter. In ಇದರಲ್ಲಿ respondent number 2, first matter ಯಾರು appear ಆಗ್ತಾರೆ? Same party before the first matter. Yes. Then we'll direct that same counsel. Yes. Shivappa S. Jati is directed to take notice for respondent number 2. Then in your case is also service complete. Only 2 cases.
3 cases.
Yes. What is that next matter? Same. Respondent is the same. Adರಲ್ಲಿ R2 ಗೆ same. Shivappa S. Jati. You are appearing for whom, Mr. Chida?
R1 only. R1.
Yes. Shivappa S. Jati is directed to take notice for R2, second matter ಅಲ್ಲಿ. ನಾವು ಪೇಪರ್ ಬುಕ್ ಯಾವ್ದ್ರಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ?
Second matter 40 for 1 ಅಲ್ಲಿ 40.1 ಅಲ್ಲಿ ಇದೆ ನೋಡಿ. ಪೇಪರ್ ಬುಕ್ ಫೈಲ್ಡ್ ಅಂತ ಇದೆ ನೋಡಿ ನೋಟ್.
ಹಾಕಿದ್ದಾರೆ. You have filed a paper book, madam. It's enough. It's common. Yes. ಇದರಲ್ಲಿ serial number 40 ಅಲ್ಲಿ filing of paper book is dispensed. 40.2 ಅಲ್ಲಿ ಕೇಳಿದಾರ? ಅದರಲ್ಲ paper book ಇದೆ. Yes. Why 2 paper books? No, that common judgment.
First appeal and the third appeal is concerned. The second one, the middle one is a different benefit.
Yes. Yes, now it is completed. Was this matter for hearing?
Government advocate for appellant Ravi Kumar MC.
For respondent.
Yes, Mr. Government Advocate. Wait for counsel, for respondent, for permission, for withdrawing that. What is this matter?
I filed this application for withdrawal of the amount. My lordship, I am more than 80 years old. So
What
I'm
is
a
that?
farmer. The crops have been destroyed by the elephants. And there is a amount which is decreed. That is 10,30,000 with 6% interest from date of filing the suit. And OS suit number is 55 of 2013. And date of judgment was 25 2019. My lordship, now I've been suffering with a lot of health issues. So 7,50,000 175 has been deposited. That is 50% of the amount has been deposited in the.
What ground you are challenging, Mr. No, that is. Basic.
My
question.
lordship, the proper evidence has been laid in the trial court, and also there is a suit. In the trial court, there is no question of this position or the title of the property. I want to take attention of my lordship in the point paragraph 10 of the judgment. With your permission, my lordship, can I read this paragraph 10?
Wait. No, it's not a writ petition suit. Now, what is that answer of the trial court regarding the title?
My lordship, para 10, I just want to read. What I have been stated in the plain and written statement has already been noticed as required by Order 8, Rule 5 of CPC. There is no specific denial of the arguments made in the plain in the written statement filed by the defendants. That is the appellant here. In particular, there is no denial of crop loss sustained by the plaintiff in the white elephants menace in the lands bearing survey number 9/1 measuring 9 acres of 0.4 acres, 19.04 acres on date 17/7/2009. Therefore, by non-traverse, the defendant shall be deemed to have admitted the crop loss caused in the suit property. Apart from the fact, there is no specific denial of the plaintiff possession over the suit property by pleading the plaintiff is not the owner of it and he has no title on the date of the incident. So there is a proper evidence conducted, my lordship, and now they have filed some additional evidence, and that is subject to my lordship.
Only dispute rights for the defendant that as on the date of the plaintiff was not an owner of the suit property, has no right to claim a damages. Both these witnesses deposit the plaintiff government has loss sustained by the township. Loss sustained, you are cultivating, there is no dispute. What is the document you have produced to show that you are the owner of the property?
My lordship, I have produced the sale agreement, I have produced the required revenue documents, whatever is
Where is
applicable.
that? Where is that?
My lordship, in my OS suit which I have produced, and I have also filed the objection in my objection for this additional.
What is that earlier degree of 26 of 1999? OS. You see your exhibits.
That is, my lordship, this is on the sale agreement. In fact, what they say is, before this incident, I was not the owner. Later, I became the owner through sale agreement. In fact, the sale agreement was already existing in 85.
Is it your case? It's a government land, not a government land. He has produced that sale deed, he has purchased that. You have to pay that compensation. To avoid a compensation, you can't just deny this title. Suppose if it is a government land, illegally is encroached, it's a different. It is not your case that it is the government land. Your casual denial that he is not a owner of that property. What is the document?
It was earlier governed by the state was governing, and the permission was given to them to cultivate the thing.
No, why it is posted today?
My lordship, we have moved that for IA 1 2023 on hearing of this IA for withdrawal of this amount, my lordship.
Paper book is filed. Paper book is filed. They will post for hearing next week. You ready, both of them?
Yes, my lord.
When do you want? That is the only point. Yes.
Let date be given, my lordship. Any convenient date of the lord.
Yes. Yes, we'll have it on 19th. 19th. Get ready.
42, Rupesh Kumar as per appellant, Chandrasekhar L.
Post this matter. Where is that? Let it. Yes, what is this? You are for the appellant. Karnataka Council for the appellant filed in a memo stating that appeal become infructuous. It may be dismissed having become infructuous. Yes. Accordingly, the appeal is dismissed having become infructuous.
For appellant,
The appeal dismissed for non-compliance of office. Last time the matter was six honorable court directed me to comply with the office objections. I complied with it. The objection date. Sorry, that.
Yes, there is a delay of 232 days in filing IA for
Poor lady, she was not aware.
following that order dated 27/3/2023 for the reasons stated in the accompanying affidavit. Delay of 323 days in filing recalling application is condoned. IA 1 of 2023 is allowed. Consequently, IA 2 of 2023 is allowed. Order dated 27/3/2023 is recalled. Hold this matter for admission.
So 44, Narayanan MR, Keppegowda for appellant, P.D. Purana.
Is where the employee,
Hmm.
one person stay, he has resigned, filed the suit for intention to be dismissed. It is not maintainable. ಆ ಟೈಮು ನಮ್ಗೆ ಕೇಳಿದ್ರೆ ಟೈಮ್
Request of learned counsel for the appellant, please this interim order is not there.
What is there?
No, interim order is not extended from, is it absolute? There. Order of the court, finally outcome of the appeal, appellant is directed to deposit 10,000 from the December onwards before this court until further order. What is that interim order passed by this court? Appellant to deposit 25,000 before this court. Next date of hearing, ಮಾಡಿದಾರ ಅವರು?
And here was allowed.
Statement of objection, call for records. In meanwhile, the impugned order is hereby stated subject to the appellant to deposit court before next date of hearing. Records ಬಂದಿದ್ಯಾ? Only till records comes, interim order has been granted. Meanwhile, now the records comes, advocate is not there.
Clarified that interim order is not extended.
Yes.
Read ಕೊಟ್ಟಿದ್ದಾರೆ.
Today matter is posted on the IA filed by the respondent for vacating the order dated 28/2/2023. Order states that pursuant to that, records office is already received the records. Learned counsel for the appellant is not present. It's the interim order. It is made clear that there is no further extension of the interim order.
That interim order is already vacated.
Already vacated the law. That effect is,
It will clarify so that like.
that's why I said there is no further extension.
By the exclusion. The permanent file the exclusion date. What is the, is that regarding the exclusion degree?
That is for you. See, there is none appear. There is no further extension of the time. It is respondent is at liberty to execute that degree.
Request for appellant.
Case notice I already issued your 8/12 on it. TCR ಕೂಡ call for ಆಗಿದೆ but again it-
Filing an appeal.
notice emergent notice issue ಆಗಿದೆ update of question.
Counsel for the appellant office objection accepted issue emergent notice ಆಗಿದೆ. Process ಕಟ್ಟಿದ್ದೀರಾ?
ಎಲ್ಲ ಕಟ್ಟಿದ್ದೀವಿ.
ಏನಾಗಿದ್ರೆ ನೋಟಿಸ್? ಎಲ್ಲಿದೆ PF ಕಟ್ಟಿರೋದು?
ನೋಟಿಸ್ ಡಿಸ್ಪ್ಯಾಚ್ ಆಗಿದೆ. ಏನಾಯ್ತು ಅಂತ ಏನೋ.
Also, let us see. No. What has happened to your notice? We'll see. ಬಂದಿದ್ಯಾ?
ಇಲ್ಲ ಬಂದಿಲ್ಲ. ಇವ್ರು PF ಕಟ್ಟಿರೋದು ಅವ್ರು ಡಿಸ್ಪ್ಯಾಚ್.
There is no report saying that what has happened to your notice. We'll verify from the office. Also,
46 Hiramat NS for appellant. Serial number 46.
yes, Mr. 46,
Sir.
IA 1 of condonation of for filing an appeal for permission to the appellant to come on record, for permission to come on. This is not necessary. Under 2 will dismiss it. Yes. IA, learned counsel for the appellant is 6. Permission to withdraw this IA number 2 of 2024 is dismissed as withdrawn. 4 of 24 for permission to the respondent for 18 to come on record. So why respondent number to come? No, you are appearing for appellant. Yes. Yes. No, you have already made them as a party. Only permission you are seeking. They are already there. Yes. Now notice has to go. No, there is a delay of 5,042 days in filing an above appeal. What is the suit for? Yes. Yes.
Paid by the appellant during the lifetime of the matter paid on 22/6/2008 without seeking permission of the court. Therefore, the appellant had independent right to respect to his father, who is the respondent number 10. Otherwise, if the appellant wants to prosecute the appellant as a legal heir of respondent number 10, taking note of the fact that the respondent died with the potential to appeal, appropriate application has been filed with the appeal and the review petition is not a party before the trial court. It is laid with only against the respondent father. So 10th respondent in this appeal, in view of the petitioner cannot be permitted to seek the review of the orders for authority to take note of all the matter. It should be dismissed not maintainable. Over. Some of the appeal present appeal does not affect the place of the failing the appropriate.
In view of that, you have filed this appeal. During the pendency, you have any stay?
Equal to 2009. There is an order by the Supreme Court to act with state. Proceedings.
Yes.
It was only and give permission for that. People 2009.
Yes. What issue notice? Although there is a delay in filing that appeal. This case, the earlier appeal has been filed in RFA number 369 of 2008, challenging very same judgment and degree. This court by order dated 3/12/2009 has granted an interim order saying drawing of final degree. The said appeal has been dismissed on technical ground with liberty to file a fresh appeal before this court. In view of that, the appellant has filed this appeal, and for that, there was a delay in filing that appeal. That is peculiar facts and circumstances of the case. During the pendency of consideration of IA 1 of 2024, stay of of 28 degree till next date of hearing. Yes, you are not there. What to do?
Well, just 1 minute I came because or because I
No, you asked that your opponent 2:30. You asked to come 2:30. The order ಮಾಡ್ಕೊಡಿ. You asked him to come was Purana. Or you take his convey this what has happened to you and tell him that I will seek for that modification of that order and will fix the date for further hearing. You just convey him and come at 2:30. Till then will not pass any order because the order has been passed. Unless his presence, I can't modify it. I just convey it to your colleague, your friends, he may accept. Yes.
Case number 47, Anjana CH for appellant, Nagesh PS.
7. Yes. For the plaintiff for a dependent, madam. Plaintiff appeal. Who for? Yes. What is that? Your case before the trial court, madam? Injunction is claiming on the basis of the title. What is the sources of your title? You have purchased that property. When? What is the defense of the defendant? Yes. What is the issues framed by the trial court? Lawful possession of the suit property proves that alleged interference. You have failed to prove that lawful possession. Why? That there is no dispute regarding your title. Court has given a finding. No document has been produced to show that you are in the possession. After 1997, no. See, have you produced the tax paid receipt? For which year? 2009, 11. Communicates in the suit body, that being the suit, the description of the exhibit, it is shown that one square cement sheet roof house, they're constructed with the mud and so on, so jungle door windows, there is no civic communities in the suit schedule, that being the case. Yes, during the pendency of the suit, you have any injunction order? Status quo was there. Yes, how issue notice. Notice are directed to maintain. Agide notice. Only that. Okay, one respondent. Yes, K-Vetter is directed to take notice. Parties are directed to maintain status quo till next date of hearing. Yes. Not admit. Why that from 2020 you have not moved the matter? There was any interim order passed by this court earlier? Delay is condoned only in last week by me only. Before that, we are not. Yes.
The only difficulty being one of the evidence of matters. Therefore, regards to the documents, etc. There was little,
Yes. But wait. Parties are directed to maintain status quo. State of hearing. 4 weeks time is granted to file a paper. Will come, you file in a paper. Yes.
Number 48, Prakash Keswar for appellant.
Yes,
Number
Prakash.
48,
Responded. Fine color. Yeah, fine.
What is this? 2020 cases ಇನ್ನು admission ಆಗಿಲ್ಲ. What is this? ಏನಾಗಿದೆ? You are a plaintiff or a defendant?
Plaintiffs.
Plaintiff. Dismissed. Why?
The partition date. Of this. Back to the partition. It was re-granted in name of one of the joint family. Same as partition.
Yes. What is your this thing?
Okay, sharp.
Okay, sir. ತೋರಿಸಿದಾರಲ್ಲ ಅಲ್ಲ ಯಾವ ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೆ ನೀವು
More.
ಬರ್ತಿದ್ಯಾ ನೋಡಿ
ಇವತ್ತು.
ಎಸ್ ಪಿ ಲೋಕೇಶ್ ಆರ್
Okay, sharp.
Lokesh R. Learned Council is undertake to file wakalat for respondent number 1 to 3. Office is directed to show his name. Yes.
number 49, Bharat Kumar for appellant, C. Babu.
Dismissal. The defendant is none other than the wife of the first defendant is the wife of the plaintiff. The plaintiff and defendant number 1 joint the property is house property. The defendant
In a suit against his wife.
please manner. Wife and father-in-law, brother-in-law, or they are not contested. They are under the plaintiff and defendant not together. They are residing separately. You cannot kindly see there are 15 of judgment.
No, property is purchased in the joint name.
Joint name. So only they seek injunction, undivided half sharing injunction could indicate it. If you are not, he is not residing in the suit schedule property. Para number 15, ink page number 25, madam.
Where is that plaintiff buyer?
Page number,
Permanent injunction between defendant agent from plaintiff.
so
Right interest over the suit schedule property.
please, madam.
Make.
Off. The preamble of the judgment being page number 12, madam. The plaintiff, Kandagatla Srinivas, filed the suit against the wife, Kandagatla, who is defendant number 1, and the other permanent injunction restraining the defendant, they reject exception from trespassing the plaintiff are undivided share. In the para number 15 of
There
the
is no dispute that 15, yes, read.
para number 15 of the judgment, madam.
Hmm.
As stated above, there is no dispute with the respect of relationship of the parties to the suit. The plaintiff has filed the suit against the defendant for fair injunction, not interfered with the is a half share in the suit schedule property. In a suit for fair injunction, the plaintiff has to establish his lawful position of the suit schedule property as on the date of the suit. In the cross examination, this plaintiff has clearly admitted that as on the date of the suit, he is not in possession of the suit schedule property, which could be evident at para 9 para 19 dated 22/4/2019 on page 4, wherein he admits that it is true to suggest that since from January 2016, he is not staying in the social property in the further line. He has stated that because of harassment, he left the social property. The suit has been filed on 7/6/2016.
Again, Manenadu.
Maneswar.
Yes, where is he? He has admitted that he is not in the position. Refer to learned counsel for the appellant Proceedings. Who is that serial number?
49, sir. Bharat Kumar.
Who is Bharat Kumar? Aswar. Getting, if he comes, we will dispose.
Number 50, Vidyulata for appellant Ashok P. Patil.
At the time of executing sale deed in favor of the second defendant,
Hmm.
though he was a president,
Hmm.
he did not get any resolution passed from the society. And what he knew, my lords, though both defendant number 1 and 2 knew that defendant number 2 was not a member of the first defendant society.
Hmm.
The sale deed was fraudulently executed in favor of second defendant. We sought for cancellation of that, for a declaration that that document is not binding on us, since it was executed by the first defendant, who was the president, without any authority and all. That's two things which require consideration of this honorable court. One thing, the trial court says that the society failed to produce any document to show that he was the member of the society. It was the duty, my lords, of we have contended, we have told that he is not a member, and whatever membership number is mentioned in the sale deed, that membership number belongs to some other person. It does not belong to second defendant. So they do not produce any document. The trial court says it was the society which was supposed to produce. We are called to prove the negative. We cannot produce the document to show he did not pay consideration. There was no resolution passed, or he was not the member of the society. It was the burden was upon the second defendant to prove that he was a member. He paid consideration. He paid the membership fees. He did not produce any such thing. Secondly, my lords, though the bylaws clearly state that it cannot be allotted to any other person, Cooperative Societies Act and the bylaws, my lords, it has to be allotted to its members only. In the absence of proof by the second defendant that they are not the members, my lords, there is an observation saying that the bylaws do not say that there is matter requires to be heard with.
First, the submission is this. The suit is not for possession. Kindly see page number 3 of the judgment, first paragraph.
Declaration.
Suit is filed by the plaintiffs for declaring it as the absolute owner of social property and for declaring the sale deed dated 5/1/2002, registered in the so and so and so. Null and void, and the same is not binding on it. Consequential relief of permanent injunction, restraining the defendant number 1 and 2 from interfering with his peaceful possession. As of the date of the suit, the plaintiff was not in possession because in 2002, there is a sale deed executed, possession certificate given in 2002. 2004, I have constructed a house residing there, and the suit is filed in the year 2010. They were aware that there is a house built on this property because there was a writ petition pending before this honorable court. Along with my objections to the IAs, I have produced a document showing that on the my side, this is a built-up area, and kindly come to my objections to the IAs. Page 14. Exhibited D1 is the endorsement of the BDA under the RTI Act, and the document given to me is at page number 15, Joint Inspection Report of 2006. Kindly come to page number 17, para 29.
Yes.
My site number is 2099, built up house, ground floor. But in the plate, they did describe it as a site. And the plaintiff was aware in 2006 itself that there is a house built thereon. And I filed the return statement in 2012. Along with the return statement, I produced the documents to show that I'm in possession and I have taken the building license. I have got the khata in my name and I'm residing there.
The only
One second, one
submission is let
Madam,
it be
one second.
heard.
Wait.
I'm only saying frame of the suit is wrong. And the trial court has once considered that in day number 30. So, this is the only point. The frame of the suit itself is wrong. Then nothing remains. I am only requesting the honorable court that at this stage itself, the appeal is likely to dismiss because the frame of the suit itself is wrong. They are not in possession, but they claim to be in possession. And they say it's a site, but already in 2004, I had built the house. It was filed in 2010. I filed the written statement in 2012. I have given possession certificate of 2002 and khata
No.
certificate.
It is for them. If they still say that, we'll demonstrate and show that you are not in the position. It is
They have failed.
no,
Kindly
that's
see.
not there before this court saying that the finding is wrong. And we have to decide.
Kindly appreciate.
See, what you said is correct. No, if there is an admission by the plaintiff saying that they are not in the position, then suit for declaration without seeking a position is not maintainable. Throughout, they are claiming that they are in the position. Let us see, we'll examine.
Their own document, exhibit the D1, their own document. And sorry, that document, though I have produced it, but they were aware in
So,
2006.
You take this advantage. If they are realized and if they are seeking for any permission to file in a fresh suit, they are not doing. Tomorrow, if you convince again, their suit will be dismissed. The appeal will be dismissed. That I request to see that evidence and records.
When the matter was disposed of, kindly get the record. This matter could be disposed of. There is no need to admit, because the point is, once the matter is admitted, lots are aware, the property gets stuck in the litigation. 10 years we have sought for the suit from 2010 till 2022. I make a request.
Yes.
that this is the only thing the frame of the suit itself is wrong. It's unnecessarily property sought to be have been locked up in litigation.
Yes.
Internal page number 30 of the judgment. The trial court has considered all this. The records are before this on. And
Yes.
those records actually belong to them. Because there is joint report. Why the Paxos have been the element of this on the repetition. So some matter of record is records are there. And you may say itself, any day we will be ready. We'll argue the matter.
Yes, we'll have it after 2 weeks, you'll ready, you'll see. No, you also verify if it is a suit for declaration, if there is no possession is there. Then, see,
Certified copy of the plate is there.
no, I'm not, no, you have not understood that. I'm asking her to answer if suit for declaration, if there is no possession, is it maintainable? It cannot.
It definitely not be.
I'm giving a caution that you have to address on that point. Then she has to think and come. No, I have seen that finding in respect of issue number 3. It is negative. They have failed to show that they are in a possession. If same thing is happen here, even if they are show that they have a title, suit cannot be decreed because there is no. We'll hear on that point, yes. Yes. No, therefore, this court is also given a hint. You see what you want to do it. Yes.
I'll try rectifying. There is a, I'll find out, I'll try rectifying. It's not in title itself.
Law permits only, we will do it. Otherwise, we can't do it. Even if I make any wrong, we have an appeal to the Supreme Court.
Instructions. Outside. I'm not going to.
No, that is true. See, thing is, whether you have a right or title over the property, person who has sold has no right or title, or if you are not in a member. You also work out whatever your remedy for other remedies. No, now you can't claim adverse position also because litigation is there. No, if a person who has executed in a sale deed has no right of title, can it be draw the title from the person who has? Yes. Have it when last week, 26th. Get ready on that. Yes. No, let us see. We were posting for that on that day for hearing, even though it is for an admission stage. Because prima facie, what he is saying is correct. Then finding is also there. If you convince, still matter has to be required, then we will admit. I said. Yes.
Number 51 adjourned. Number 52, Chokka Reddy for appellant, Keshava Bhatia.
Friendly person.
52. Yes.
The respondent filed the apparent injunction for the trial. Defendant number 1 has filed court reply. Respect of 32 survey number 31. The plaintiff should for the trial court, the site number 12 farm in survey number 32.
Suit is decreed.
It's decreed. Court reply is rejected.
For the plaintiff,
I have the first defendant.
plaintiff by hereby degree with the cost defendants, their agents are hereby permit injunction interfere with the police. What is your defense before the trial?
Can I please this? I have filed a suit for injunction. I obtained an ex parte injunction order that was made absolute after hearing it. Was it 2016 or 17? From since that day, I have the benefit of injunction order. Now my suit is decreed also. So therefore, there is no question. Decreed, my lord, permanent injunction is granted.
Let us see if he is not make out a case, I may dismiss it also.
That's it.
Let
As far as the admission is concerned, it is between the court and.
Yes, it
as
is
far
a
as
first appeal, it's
Yes,
right of.
as an interim order is concerned, there is no question of granting any stay because I had the benefit throughout for the last few years now, not for days.
Let us see. Yes, what is your defense before the trial?
My defense is that the suit property acquired by the father of the first defendant, along with the defendant number 2, 3, and 4 are brothers. Not that the 2001 the brother defendant number 4 has executed the one Ravi site to the plaintiff in survey number 32. Later, family members filed the suit 2004. That suit was decreed against which RFA has been filed. In the RFA, the compromise decree has been entered between the parties.
Yes.
Wherein the 30 kuntas, including the suit property allotted to the first defendant.
Yes, we'll admit it, we'll bear that matter. Yes.
Allotted. That the trial court come to conclusion that the court defendants never produced any documents to prove his position. In para number 20.
I will hear. We'll admit it. Yes, heard. Admit. 4 weeks time is granted to file a paper.
53, Venkatamudi Shetty case for appellant, Shankaramba Viyar.
These have been ordered
You are appearing for?
appearing for appellants.
Really the delay.
Condoned and as for the
What is
entered
the-
appearance.
What is
the suit for permanent injunction has been dismissed, my lord.
You are the
Yes.
plaintiff.
I am the plaintiff. We are the plaintiffs.
Why it is?
Based on para 19 of the judgment, this ground, the trial court has dismissed it.
You are claiming a title
Title
on basis of
my father had purchased the property from the grandfather of the defendant by way of GPA, affidavit and agreement to sell. Because since the matter was, the land was revenue.
why trial court has
Trial court has, at para 19 may find it is. The property has not been, is different from client para and 19.
para?
Para 19 of the judgment, in page
What?
32.
What?
EW1 is the defendant number 1. He has stated in his cross-examination that the signature as R. Venkatesh in exhibit P4 is not the signature of his father, and the signature as Lankappa in exhibit P5 is not the signature of the parental uncle Lankappa. However, he has admitted the signature of Munichandra in exhibit P4 is the signature of parent uncle. But it is not sufficient to prove the case of the.
No, what is that exhibit P4 and P5?
Is the agreement to sell and GPA.
ಆಯ್ತ್ರಿ agreement deny ಮಾಡಿದ್ರೆ you can say that title. Why court said identification of that location of the suitable property? What is the difficulties in vacation? See, if the sale deed is denied, then your title may be under cloud. But trial court said property, considering that evidence available before this court, I am of the opinion that plaintiff has failed to identify the location. Where is that finding?
Location mirror. Right, para 16 mirror. Finding
Regarding that identity of the property, only the finding.
para 14 mirror. Eighth line. Para 14. In page 27 mirror. Eighth line. Therefore, the description of the property in plain para number 2 and the description of the property in plain schedule must be the same. But in plain para 2, ward number 55 is mentioned. But in the plain schedule, ward number 55 and ward number 182 are mentioned. The 182 is established ward. 182 has been given. In para number 2, the measurement of the property is east to west 20, north to south 34. But in the plain schedule, the extreme extent of the property is 20 into 40 feet.
Why that discrepancy?
Mistake it is mentioned.
Plain tell you there.
The actual.
Where is the plain? This ಮಾಡಿಲ್ವಾ? Where is the plain property? Plain deep settled that during the entire summit, the site very situated for 20 and 34 feet.
Exhibit P4 also
So
it is mentioned as 20.
ಹೆಂಗ್ರಿ ಪ್ಲೈನ್ ತಯಾರು ಮಾಡ್ತಾರಲ್ಲ ಯಾರು ಎರಡನ್ನೂ ಒಂದೇ ಸಾರಿ ತಯಾರು ಮಾಡ್ತಾರೆ ಅಲ್ಲಿ ಎರಡನೇ ಪಾರದಲ್ಲಿ ಒಂದ್ ಹೇಳ್ಬಿಟ್ಟು ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ ಏನ್ ನೋಡ್ಕೊಂಡು ಮಾಡ್ತಾರ್ರಿ ಬಿಕಾಸ್ ಆಫ್ ದಟ್ ಪಾರ್ಟಿ ಸಫರಿಂಗ್ ಅಲ್ಲೇ ಇದೇನು ಐದ್ ಪ್ಯಾರ ಇದೆ ಇಟ್ ವಿಲ್ ನಾಟ್ ಟೇಕ್ ಮೋರ್ ದೆನ್ 10 minutes ಫಾರ್ ದ ಲಾಯರ್ಸ್ ಟು ಟೈಪ್ ಇಲ್ಲಿ ಎರಡನೇ ಪ್ಯಾರದಲ್ಲಿ ಒಂದ್ ಹೇಳಿದ್ದಾರೆ, ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ ಒಂದ್ ಹೇಳಿದ್ದಾರೆ ಪ್ಲೈಂಟ್ ಅಲ್ಲಿ. ಪ್ಲೈಂಟ್ ಇಸ್ ದ ಬೇಸಿಕ್.
Document the 2040 is there. Now a possession release.
Yes, what is that during the pendency of that suit? You have any?
Unfortunately, there was no.
Yes.
Since we are in possession.
No, if you are not having any
Section.
because interim order from 2019.
Status quo order kindly be granted.
What is that? Where is your application? Is there any threat after that? What is the document you have produced that you are in the possession? It's a open site or in a vacant site or in a
House is small, house is.
what is the documents to show that you are in the possession? In electricity bill or
Produce ಮಾಡಿ.
where is that?
Exhibit. Electricity. At, election card and voter ID card and Aadhaar card.
Biddre ಅದು present position ತೋರಿಸೋದಿಲ್ಲ. Present position ತೋರಿಸೋದಕ್ಕೆ ಮನೆ ಆದ್ರೆ
25 is there.
ಏನದು?
Electricity
ಯಾವ ತಿಂಗಳಿದ್ದು?
in my name.
ಯಾವ ತಿಂಗಳಿಂದ?
19 year.
Yes, heard. Issue notice. ಒಬ್ರೇನಾ ರೆಸ್ಪಾಂಡೆಂಟ್?
Respondent ಇಬ್ರು ಇದ್ದಾರೆ. Both are served.
ಎಲ್ಲಿ serial number?
Has filed.
53. Yes. But admit. Parties are directed to maintain status quo till next date of hearing. Which time is granted to file a paper.
Udita Ramesh for appellant.
Yes.
Possession.
Yes.
Dependent one remained expert.
Hmm.
Dependent one claimed to be the owner.
Hmm.
Dependent one and other people. He entered appearance. Creative letting evidence. Cross examine. Dependent number 2, it has GW1. Letting evidence.
With the pendency.
Pendency. Cross which is authority. Mistake which the trial court does is at para 17.
No, LRs has not been brought on record.
LRs were not brought on. No, LRs were not brought on record.
No, that there.
Yes, LR, one LR was brought on record.
Hmm.
But what happened was trial court appreciating the evidence. The law seems to be.
No, they have relied on that.
No, that evidence will remain on record. You can't discard the evidence. Though the probative value will go down, the court has to consider that evidence also. I marked agreement to sell, I marked power of attorney, affidavit, etc. Para 17 of the impugned judgment paid 31. This is where the trial court went wrong. Maybe the trial court.
Yes.
Defendant number 2, although examined himself as DW1, got marked D1 to D3. His death was reported before his evidence could be completed, before it could be counted. Therefore, his evidence, since his evidence is incomplete, evidence is discarded.
That cannot be. Whatever that evidence given, it has to be
It will
taken
remain
out.
on record. Whether you choose to afterwards accept the truth or not is different. Well, with this, what happens? The whole course of the judgment changes. Or you the full document produced.
Yes. Now that declaration has been given.
Possession also they have ordered 3 months.
Deliver that vacant. Heard. To notice. Parties are directed to maintain status quo.
Stay up with the
Status quo is how can the court execute?
with reference to his decree, I can't discuss. So then you say status quo parties by act of parties. That's the order of the court.
Yes. Day of judgment and degree dated 31st October 2023 passed by 13th Additional City Civil and Sessions Judge Bangalore in OS number 16408 of 2005 till next date of it.
Serial number 55 adjourned. Serial number 56, B. Vishwakumar for appellant. Let's check the 50.
Yes, sir, the request, use this matter next week.
Number 57, Nagaya, Umesh Ji for appellant.
Next week.
Yes, sir, the request, use this matter next week.
One submission matter, another connected matter.
Hmm.
I'm a pay for the respondent. And my name is disappeared as a
request your lordship,
respondent.
at the instance of myself and the respondent in this matter, these two matters have been detached from each other.
Hmm.
My learner friend is a respondent in another matter.
Hmm.
He has no locus to make submission to club together again. By virtue of the order of the Supreme Court, these two petitions have been detached.
I will make one submission. First of all, I will make submission. Earlier, parties taken make the fight. And he voluntarily make submission before this one. I will personally argue, party in person. Thereafter, this honorable court, some clarification he could not. Again, I filed the wakalat on his behalf. Thereafter, my name has been mentioned. Today, my name is not.
You have filed an wakalat,
Yes.
want to show your name, that's all.
Earlier,
We are arguing in 57.
I am
57.
only 57. That's RFA 380/60.
He is there.
58.
He said that.
No, that 57,
Sorry, 58.
57 you want time, Mr.
No, not that.
57 you want time. 58 you want to argue. 58 you have filed an wakalat.
Already filed a wakalat. I am already on record. Your lordship has been earlier. My name has been reflected. Now I don't know why it has been left over. ಅದೇ ನಿಮ್ ಕೊನೆಗೆ ಇದು ಡೇಟ್ ತಗೊಳ್ಬೇಕಾದಾಗಲೇ ನಾನು ಅಪೋಸ್ ಮಾಡ್ದೆ.
Number 58, Nagaya for appellant.
My name has to be mentioned. After December 8th ಗೊತ್ತಾಗಿದೆ. I have filed the wakalat.
ವಕಾಲತ್ ಹಾಕಿದಾರೆ ಅವರು ಅಡ್ವೊಕೇಟ್. When you have filed an wakalat, Mr.
November itself, my lord. 6/11/2023. Yes,
your wakalat is there. There is a mistake of office. Order ಆಗಿದೆ ಅಂತ ನೋಡಿ. Two suits are different,
But two sides.
two sides. Then why do you want to adjournment of first if it is a
Into file paper.
paper book is dispensed? Paper book is dispensed ಅಂತ ಇದೆ.
Second, we will argue the matter on the next set of paper.
index.
ಅಲ್ಲಲ್ಲ ಇದೆ ನಿಮ್ದು ವಕಾಲತ್ ಇದೆ. You said there is an order of the court to show your name. Just I am verifying why that order has not been complied.
Earlier, my name was reflected.
No, then you have retired from the case.
Earlier, long back.
After that, last occasion your name was there.
Yes.
ಹಿಂದೆ ಅವರು ರಿಟೈರ್ಡ್ ಆಗಿದ್ರು ಮತ್ತೆ ಫೈಲ್ ಮಾಡಿ his name has been continued. Today it is not shown his name.
Yes.
You are ready? 19th.
I am the respondent.
Ready? Yes, what is that?
Plaintiff's appeal. Plaintiffs have filed the suit for relief of declaration and possession against the respondent number 1 to 3. Respondent number 3 is the Pollution Tailoring Cooperative Society.
Yes.
Respondent number 2, according to the question of the defendant's respondents, has harbored the layout in survey number 37/2, which belongs to the one of the property. And sold the site in favor of respondent number 2. Who in turn sold the site in favor of respondent number 3, respondent number 1. When respondent number 1 attempted to interfere with the appellant's possession, they have however done such a document found that they have not sold the land in favor of respondent number 3 society, and inquired with the jurisdiction of registrar. According to their version, it was registered people, city and sale agreement, registered people. Verified and found that they have also issued endorsement stating that no GPA set to be executed by the appellants in favor of respondent number 3 society registered in this office. And thereafter, we have issued the notice demanding respondent number 1, 2, 3 to interfere with the plaintiff's position, surrender position, said which is not at all in existence according to the appellant's hearing.
Why the trial court has dismissed?
Dismissed on the ground that holding that there is already a sale deed executed by the respondent number 3 society in favor of respondent number 2, in turn respondent number 2 in favor of respondent number 1. Since the date of first sale deed executed by the society, suit is barred by limitation. Thus, we are not the parties to the said transactions. We are not aware till the attempt made by the respondent number 3.
Where is the finding? From the date of knowledge 3 years.
Yes.
What are the issues framed by the trial court?
Kindly see. Issues are at page number 24. In page number 24.
Suit is
Suit
in
is
time.
for declaration and possession.
No, suit is in time is issue number 4.
Yes.
You show me that issue number 4.
Issue number 4, whether the suit is in time.
Yes, you
For
read
which
that.
the court below,
From para 18.
para number 15,
No, issue number 4 is para 18.
BW1 in the oral evidence has clearly stated that to be aware of the construction of the building as well as the GPA. This knowledge about the GPA is said to be in the year 1986 itself. The declaration really pertaining to the GPA dated 12/3/1982. The state date executed by defendant number 3 in favor of defendant number 2 is dated 22/3/1982. The cause of action is described to have arose on 12/3/1982 and 83/2002 on issue of the legal notice. By virtue of the admitted fact, defendant number 1, therefore, it is necessary to extend the benefit of citation so and so in favor of the plaintiff, defendant. When it is within the knowledge of the plaintiff in the year 1986 itself, then there has been actual approval of the right and the limitation period begins to run. Hence, the suit filed by the plaintiff in the year 2002 is therefore part by limitation, and this issue is answered in the affirmative. If you are not aware of, you have not issued the notice in the year 1986.
No, show me your evidence.
Please.
What is that notice?
Notice is when he has interfered, we have demanding him to surrender person because there is already a sale deed executed by the third defendant in favor of independent, the first defendant.
That is
Let me see
2002. Yes. Now, where is that trial court has held that you have knowledge in that?
Yes. That's what the paragraph number 18, the trial court.
You will see your PW1 evidence.
Exhibit P60 may can be seen. That is dated 11/11/2002. Exhibit P60. Page number, paper book 159. That is a legal notice issued by the plaintiffs.
No, that is different. Legal notice, there is no dispute. Immediately after you have filed in a suit.
Immediately after this notice, we have filed the
No,
suit.
legal notice, they have extracted that you said that cause of action is 2002.
Please.
But you have any knowledge in the 86 that extracted from your
Yes,
evidence
yes,
PW1?
yes.
Very good.
Finally, paragraph number 11, page number 11 of the slide. I take your lordship to the evidence.
Yes, evidence.
Evidence of PW1. Paper 24, paper.
Yep. Read.
Paragraph 7 में कहीं भी same. Paragraph 7. I was that BDA has supposed to form an alternate road which is passing through our land in the number 42 of to the course of the creation of things, the Bengal Development Authority has issued an award notice in section 22 of the Land Acquisition Act in our name, father's name, calling upon them to produce the title documents and hand over possession of the land, enabling the authority to apportionment of the compensation under LAC number 4/99/2000 dated 24/3/2001. Our fathers, in response to the said notice, have filed a document to our title claiming compensation with CDA, and the said case is pending for adjudication before. That being the case, the defendant has both the signature of my father and the signature of grant number 2 and 3 created fabricated general property dated 12/3/1982 itself, as if they have appointed defendant number 3 as their lawful power of attorney to do act deeds and things mentioned above. Therein, the defendant number 3 pretending to be the GPA registered GPA holder registered in the office of Bangalore. Defendant number 3 society is known for its work of fraud, forgery and cheating in Bangalore. Defendant number 3 society indulged in such cases of creation of documents relating to somebody's property as well and sell the lands to others as if defendant number 3 is the owner of the said property, even though they had not acquired valid title. Defendant number 3 indulged in creating the antidated documents also. The plaintiff 1 to 3 have secured the copy of the early general property dated 12/3/1982, which is forged by the defendant number 3. Therefore, they made effort to bring out the facts forgery fraud made by defendant number 3 in reading GPA, and they have obtained an endorsement from the sub-register Pasumuni Bangalore, who stated that no such document is registered in their office as mentioned in the GPA dated. I suppose that the land in survey number 47/2 as an agricultural land there, and nobody has farmed the layout as on the date of the GPA. But as against the setback, it is mentioned in the GPA that sites have been farmed, and our fathers, right number 1 to 3, herein have appointed different number 3 as their attorney of the site number 1 to 144, which clearly goes to show that the fabrication of the GPA and forgery of the document fraudulently, I depose that it is practically to farm 144 sites in 2.12 hectares of land.
Yes, Mr. Where is that admission that he has aware in the year 1986?
Even one submission. I can see issue number 3. They have sold the property.
One submission. In addition to that, the defendant in this past examination has unequivocally admitted the plaintiffs are the abused owner of food schedule property.
No, I am asking the question to show me where is the finding that he has admitted that he has aware in the
year 1980s.
That is the finding of the trial court.
Cross-examination is there. Cross-examination is birthday. Your lordship, before that, your lordship can see issue number 3.
That I will come to that.
First issue number 3, they sold the property, then they have no right to claim. Your lordship kindly see the issue number 3. Then I will come to issue number 4.
No, you first answer that issue number 3. Why
Yes.
the trial court has held that he has knowledge?
I may be permitted to read the cross-examination portion of
Any-
PW1.
Evidence includes cross-examination.
Yes,
also.
yes, yes. Page number 11, DCR, my lord, 1992.
Paper book kilwani matra. Land acquisition ಆದ್ಮೇಲೆ ಏನಾಯ್ತ್ರಿ litigation?
It is compensation was paid in respect of the portion acquired by the BDA for formation of the.
No, this portion is not acquired.
It is beyond the acquisition.
Then why that mentioning that case is pending and all? If it is not,
Obviously pending. As of the date of filing of the suit, That LAC case was pending before the.
No, that is not related to this property.
How?
How it is related?
How it is, and because we are the owners of landing.
No, they are not saying you are not owner, you have sold it.
Yes. That they have to.
That is the
That
establish.
they have to
That
establish.
case is nothing to do with this
They
case.
have sold in.
Exhibit D1, my lord. Exhibit D1.
First, ನೀವು ಅದನ್ನ ಬಿಡ್ತಾ ಇದ್ರಲ್ಲ ಅದಕ್ಕೆ ನಾನು ಈ ಕ್ವಶನ್ ಕೇಳಿದ ಫಸ್ಟ್ ನೀವು ಆನ್ಸರ್ ಯು ಆರ್ ನಾಟ್ ರೆಡಿ
ಅಲ್ಲಲ್ಲ ಇಲ್ಲಿ ನನ್ನ TCR.
ಐ ಕಾಂಟ್ ಗೋ ಹಿಯರ್ ಅಂಡ್ ದೇರ್
ಒಂದೇ ಒಂದು
ಆಯ್ತು ಯು ಗೆಟ್ ರೆಡಿ ಬೈ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ದಿಸ್ ಇಸ್ ದ ಒನ್ಲಿ ದೆನ್ ಯು ವಿಲ್ ಸಿ ದಟ್ ಟೈಟ್ಲ್ both case will see together.
And he clearly admitted my mother has been sold. We have no local. We have.
That is
That's
hard to the
see,
defend.
once
What
the
is the status of the
witness has
third
been
defendant?
admitted, I need not prove.
What
Witness
the-
admitted in the witness
What's the
box
title of the
and
third defendant?
confronted to him, the sale deed existed.
Yes,
This
yes,
is only my case. It issued for also. Limitation.
yes.
My name may
Office
be
is,
called.
yes, yes. Office is directed to show the name of also counsel appearing for respondent number
One.
respondent number 1 in the cost list. Yes.
But date may be fixed, my lord.
Next week, Bharat, next week. Yes.
59 adjourned, number 60.
69, 69, my lord.
Even Kumar,
59.
69, I am appearing for the respondent.
59, sir.
No, you are in 59.
59,
59,
sorry. I heard it as 69. Sorry, I am sorry.
Serial number 60, my lord.
60.
60. I appear
Yes,
for the
yes.
respondent, my lord.
Rajeshwar appear for appellant,
Yes, Mr. Jeevan, they want style.
No, no, my lord. May I request for next week or thereafter?
Yes.
Whichever the date is convenient to them.
Yes, sir. The request of counsel for the appellant. Is this matter next week? Next week, get ready, miss. Yes.
Much appreciated.
61, Kashyap and for appellant, P.K. Venkatesh Prasad.
For the appellant. Hmm.
They claim to dispatch various couriers to various places on my behalf. Defendant is a rewards fulfillment company. Essentially, it's a lot the same these big retail shops where they say you will enter lucky draw for space in the washing machine, second place, one. We provide that washing machine mobile phones, these kind of rewards. Their claim is not entirely based on 2 invoices. My appeal, the judgment is entirely on the basis of no cross-examination has been conducted, no defendant evidence has been laid. So I will show the order sheet. My primary arguments on natural justice and 2 persons.
No, that, why you have not cross-examined?
Not I asked for judgment. On the second day, I took a passport to 3 o'clock. By the time I reached court, matter has already been called out, cross has been taken as nil. On the next day, it was for defendant evidence. I again asked for passport.
Service to the defendant and the agreement letter, so on, so. Permit you, the defendant prove that the plaintiff company has not provided any service against defendant invoices raised in the so on. Yes.
That thing is on the, even on merits, I will show how issue of the work not been found in favor of the plaintiff. Because the only document they produced is invoice. Whether they prove services have been provided to me. And invoice is not proof of service. No delivery.
No, you have not produced any documents.
I have produced with the written statement not marked in evidence because on the first day itself my evidence is taken as nil. Argument is taken as heard. My lord will see the order sheet. Not a case, my lord, where multiple adjournments were sought for and the trial court said enough is enough. This is a case where on a day-to-day basis trial court is closed the stage.
No, why you have not cross-examined PW1?
My lord, on the day trial was set for cross, we took a pass out 3 o'clock. By the time my senior colleague reached the afternoon, matter had already been adjourned, case stage was closed. Next day, independent evidence.
Yes, sir. You have not filed any application for recalling.
I sought for a password, file application for recall, denied, saying no ground paid out.
What is the date?
Date is 3/11/2015. From issue my lord, just prior to that, so how the trial was conducted. It's a very short order. So my lord, from the time of chief. 24/3, page number 5 of the order sheet is my lord.
What issues have been framed? What is the issues are framed on?
No, we can't find fault with the code that if had disposed of early. Because
I
we are
understand.
also.
Absolutely, my lord. But 1 day at least should have been granted is my submission.
Yes, we'll see that, yes.
24-3, my lord, list of witness, list of documents not filed, settlement not taken place, call bar 27-4. 27-4, no representation for defendant, there is no entry in the order sheet, only absent present is marked, there is fixed by 8-7. 8-7, PW1 is further examined, P1 to P8 are marked, advocate for defendant, place time for cross examination, 21-8, my lord, will see what happens. PW1 and his counsel called out absent, no representation, evidence of PW1 is discarded, call on for defendant evidence.
PW1 and his counsel.
Called out absent.
Hmm.
No representation of no representation, full stop. Evidence of PW1 is discarded. Call on for defendant evidence.
No, this, it's in handwriting.
Yes,
PW1 and his counsel
called out absent.
absent,
No representation.
no representation.
Evidence of PW1 is discarded.
PW1 is,
On first day that PW1 did not come for cross-examination, his evidence was discarded. Matter is then posted for defendant evidence. Suit itself could have been dismissed in that case, but in any of. On the next date, my lord, advocate for plaintiff filed I number 3 under order 18 rule 17. Peruse the I, same is allowed on cost of piece 300. Call on for cross-examination. That order is recalled, the order of discarding. On the next date, PW1 is present. Counsel for defendant place time, call on 8-10. On 8-10, my lord, PW1 is present. Defendant and his counsel called out absent, no representation, cross-examination of PW1 is taken as nil. On this day, my submission is that I was slightly late to the court. By the time I arrived, damage had already been done. On 3-11, defendant is absent, advocate for defendant praise time, no grounds, prayer is rejected. Defendant evidence is taken as nil, heard, call on for judgment. There was no arguments, nothing, my lord. This has been all in first round.
8-10.
8-10, my lord, is when cross of PW1 was taken as nil.
311 post ಮಾಡಿದ್ದಾರೆ.
311 post ಮಾಡಿದ್ದಾರೆ. 311 defendant evidence taken as nil.
Month time has been given, not day to day, mister. Not day to day.
Not day to day, my lord.
Then
Occasion, defendant evidence was taken as nil. Opportunity could have been granted in my submission.
yes, some 311 defendant is absent, advocate for plaintiff is not. Yes, who is appearing for other side?
Okay, Venkatesh Prasad.
To address on merits and also for my lord the invoices. Because the only on merits, the only submission, invoice could not have been the only basis to finding of proof of service. There is written statement has specifically denied that any services were given to me at all. That invoices are manufactured for the purpose of the suit.
Yes, other side is not correct. This appeal is filed by Section 96 with order 41 rule 1 of CPC challenging statement in degree dated 4th December 2015 passed by 38th Additional City Civil Judge Bangalore in OS number 1221 of 2014, whereby suit filed by the plaintiff is decreed. For the sake of convenience, parties are referred to the ranking as per the trial court. Brief facts of the case. Plaintiff is a company registered under the Companies Act, carrying on the business of courier, extending logistic support regarding the travel and transportation apart from that, the plaintiff company is also providing high quality service coupled with transportation. there was an agreement between plaintiff and defendant dated 15 to 2015 for providing courier service. The defendant has approached the plaintiff company for providing courier service for delivering certain consignment to its various places of their destination across India. The dispatching of the delivering the consignment entrusted by the defendant to their various destination, informing the defendants possibilities except any other documents required to be produced before excise and taxation department, the check post whenever needed. In the month of April 2013, defendant availed the service of plaintiff company for transportation of certain consignment belonging to them to deliver the same to various places as mentioned in the waybill. For that service, the plaintiff has claimed the amount of rupees 42,500. There are also service provided by the plaintiff company to the defendant in the February 2013. For that, they have raised the invoice on 28/2/2013, sum of rupees 2,85,101. Out of that amount, the defendant has paid only 1,48,026 rupees. Balance of 1,79,649 together with 18% has not been paid. Hence, the plaintiff has filed the suit for recovery of money. On service of summons, defendant appeared through the counsel filed in a written statement denied the case of the plaintiff, attended that he is not liable to pay 1,79,643 to the plaintiff. Also denied that they have not provided any service against the said invoice in the month of February and April 2013, sought for dismissal of the suit. On the basis of the pleadings of the parties, trial court has framed following issues. To the case, the plaintiff has examined itself as PW1, who has examine one upward into as PW1, got marked E documents exhibit P1 to P8. No evidence has been adduced on the defendant side. On the basis of the evidence of the parties and material available on records, trial court has answered issue number 1 affirmative, 1 and 3 is affirmative, 2 is negative, and decreed the suit directing the defendant to pay sum of rupees 1,79,643 with 6% interest for the date of the suit till realization of the entire amount. Being agreed by the same, Defendant has filed this appeal. So and so learned counsel appearing for defendant appellant has contended that trial court has not given proper opportunity to the defendant to defend his case. They are not permitted. They have not given opportunity for the defendant to cross-examine the plaintiff. The plaintiff evidence, defendant evidence is also not examined. If this court grant one more opportunity, the plaintiff, the defendant will establish his case. None appear for the respondent or the learned counsel for the appellant. For consideration in this appeal. Whether matter required to be remitted back to the trial court to give one more opportunity to the parties to the facts and circumstances of the case. It is not in dispute. There was an agreement between the plaintiff and defendant dated 15/2/2013. There is no dispute, Mr. Agreement.
Circumstances are disputed on how it came about.
Yes, that's yes. The claim of the plaintiff that the defendant is due sum of rupees 1,48,000, 1,79,643. Therefore, plaintiff has filed suit for recovery of money. Defendant has denied the same, stating that there is no any due as claimed by the plaintiff. To disprove the case of the plaintiff, even though defendant has filed an written statement, has not examined any witnesses and also not cross-examined the plaintiff. Under these circumstances, to give one more opportunity to the parties, I am of the opinion the matter requires to be remitted back to the trial court. Give one more opportunity to the parties. Accordingly, the appeal is allowed. Judgment and degree dated so and so is set aside. The matter is remitted back to the trial court. The direction to reconsider that matter afresh after giving an opportunity to both the parties to adduce additional evidence, produce additional documents. The parties are directed to be present before the trial court. On 29th February, without any further notice. On 11th March, without any further notice. The trial court is directed to dispose of the appeal, dispose of the suit as expeditiously as possible.
Number 62, Vinod Prasad for appellant, absent member Rahul Karyappa.
Yes, Mr. What you want? You asked something in morning. Now that but there is a delay in filing the cross objection, will come down, Mr. There is a delay of 104 days in filing a cross objection. Year 1 of 2016 is filed for continuation of delay. That affidavit for the reason stated in that accompanying affidavit. Delay of 104 days in filing a cross objection is controlled. Year 1 of 2016 is allowed. Yes, next week. Yes, Mr. Srinivas Prasad. Vinod Prasad, what? He can need. 27. It is matter on 27.
63, Vishweshwaraya for appellant, Virana Mithireddy.
Yes, Vishweshwaraya.
Right by the allied. Yes. Issues.
What is the relationship?
Relationship is admitted. There is no dispute.
Where is that genealogical?
Genealogical.
Page 45. Page 45.
Page 45. One Kiranagoda, yes, Kiranagoda is the propositor of the family. Wife is Lakshmi Devamma.
Yes.
They are Manad's five Manad's five daughters and one son.
One son.
His first daughter Rudramma, she is the plaintiff.
Daughter has filed in a suit against that brother and sister.
Yes, yes. His Gauramma Manad's she is no more and
yes, Yellas
are on record as defendants
yes,
1
yes.
and 2.
Now that why the suit is dismissed?
Dismissed on 2 grounds. The trial judge holds the first issue, page 22.
Yes.
Whether the plaintiff proves that scheduled property to joint family and she in joint position of the same. Issue number 1, partly in the affirmative.
Andre? Yeah, now whether joint position is not proved or joint family.
Joint family is not in existence.
Then is there was a partition earlier?
That's no registered partition as such. Then the second issue, whether the fourth defendant proves that scheduled properties have been allotted to share of her husband in an oral partition, partly in the affirmative.
Now that only issue is that there was a partition earlier.
There was a partition earlier, that is the
Defense.
oral partition.
That has been proved or not the issue?
Yes, that is the issue.
Now where is that?
And another thing is the alienations that have taken place are subsequent to the act came into force. After the amended act 99/2005, all the alienations have taken place subsequent to amended act. That is after 99/2005. The learned trial judge observes that all the alienations are saved under section 6A because it is prior to 24/12/2004. But as per the registered sale dates, all the transactions have taken place after 99/2005.
That is not saved.
That is not saved.
Now first thing is that you have to prove there is no oral partition.
Yes, definitely.
If there is no oral partition, then now If the transaction is after that amendment, then it is open for the partition.
Yes, madam. That's why your lordship may kindly see for they set up oral partition, saying that these properties are allotted to the share of Veerbhadraya. That is my lord's fourth defendant. Your lordship may kindly
This
see.
properties ಅಂತಂದ್ರೆ ಇದು ಬಿಟ್ರೆ ಬೇರೆ ಯಾವ್ದು ಇಲ್ವಾ ನಿಮ್ದು?
ಬೇರೆ ಯಾವುದು ಇಲ್ಲ. ಈ ಪ್ರಾಪರ್ಟೀಸ್ ಬಿಟ್ಟು ಬೇರೆ ಯಾವುದು ಇಲ್ಲ. They say that my lords, there was a house standing in the my lords,
There is that reasoning given for
yes,
that.
yes. Your lordship may kindly.
Is there any issue regarding that oral partition?
A second issue. Second issue ಹೇಳ್ತಾರೆ. Whether the fourth defendant proves that scheduled properties have been
Yes.
allotted.
Yes,
Share
issue
of
number 2.
husband in the oral partition, partly in the affirmative, the two.
Yes, you read that.
I may read from issue number 1, so that how the learned judge.
Issue number 1 ಏನಕ್ಕೆ ಹೇಳಿ?
Issue number 1, partly in the affirmative, joint family.
ಆಯ್ತು. ಇಲ್ಲಿ issue number 1 partition ಆಗಿದ್ ಪ್ರೂವ್ ಆದ್ರೆ ಅದನ್ನ ನೋಡೋ ಪ್ರಶ್ನೆನೇ ಇಲ್ಲಲ್ಲ. If it is not proved, then it's will come to that second issue. First you read that second issue.
Second issue. Yes. It starts from page 28.
Yes.
It is specific contention of the fourth defendant. Madam, fourth defendant is sister-in-law, that is Veerbhadraya's wife.
Yes.
Specific contention of the fourth defendant that if at all item number 1 and 2 have been vitiated in the name of her husband, it has only an account of the oral partition which took place in her family. So, my lords, according to her, because the mutation was transferred into her name after his death, therefore oral partition has taken place.
ಯಾರು ಅದು? Defendant number 4
Defendant number 4, Brahma.
Brahma is your brother wife.
Yes, yes. Brother died. After his death, my lords, the
Only one legal error is brought on record.
after
See, he is the only a male member.
yes,
Automatically revenue entries will be stands in.
Right.
That
After
cannot
his
say
death.
that it is a partition. See, her evidence.
Maybe, well, other properties there. That is not discussing now.
my lords, other
Given it and she availed the loan and that property was auctioned by the authorities and she in the auction her own daughter-in-law purchased the property. That is all silent.
my lords,
That is
the house was
that's
the house was
property.
there, my lords. House was there. It was put to public action because my lords, there was a loan outstanding.
Who has taken loan?
That's loan was
Way before.
Wait, he has to answer. I put a.
that was put in public action. Our daughter-in-law has purchased the property.
What is your right for taking in a loan on that property? That shows that there was a partition.
No,
This
no.
house has been allotted to you.
No,
Then
not
what is
that,
your
not
right?
that, Not that. Your Lordship, just
See,
will complete
If you
this.
see that some properties in the name of some person, some of is there in your name, that shows that partition. That is what that Supreme Court said. If there is an oral partition, if it is followed by subsequent documents, then it is good.
That I will clarify, Your Lordship, I'm going to say. Just read issue number 2, so that we will clarify. It is specific contention of the fourth defendant that if at all suit item number 1 and 2 have been mutated in the name of the husband, there's only an account of the oral partition took place in our family. DW1 in our affidavit para number 2 contended only because of this oral partition, house bearing old ginger number 211 and new number 219, which are house and vacant rights state Nusapura, fell to the share of the plaintiff.
Yes.
Defendants 1 to 3 and 5, who are the daughter and the daughter of late Chikkayya Rannagoda and scheduled properties, fell to their share. According to DW1, the properties allotted to plaintiff defendants 1 to 3 and 5 were more than worth 30 lakhs. Hence, after the death of her husband, all the revenue documents in respect of the scheduled properties got mutated in her favor. In this regard, this DW1 has placed exhibit D1 and D2. With these documents have gone through, they have shown before the court that plaintiff and her son have raised loan from Karnataka Sericulture Marketing Corporation by mortgaging this house and vacant site, and as they failed to repay the said sum to the said corporation, these properties were brought for public action. In turn, it was purchased by the daughter-in-law of PW1. Even though in the cross-examination it was elicited from the mouth of witness that she has not produced any documents to show that both properties are the self-acquired properties of Veerbhadraya. And there is also admission that suit item number 1 was acquired by late Hirannagoda
But fact of the matter is how plaintiff came in contact with Ginger number 211 of Narsapura. This fact requires to be made clear by the plaintiff. It is also the attack on the part of the defendant 6 to 9 that excluding the house and a vacant site, only suit item number 1 and 2 properties are concerned. They have been targeted by the plaintiff to which defendants 1, 2, 3 and 5 have given consent. Under such circumstances, as PW1 has miserably failed to show how they acquired house and vacant site and why exhibit D1 and D2 took place, the only inference to be drawn is that there was an oral partition.
That's what I must. What is your right to give a mortgage? That shows that that property share has been allotted to you.
That's it cannot be taken in that way, madam.
No, that is what that.
That's
No.
oral partition. Oral partition, madam, they must because they have set up oral partition, they must show that under
They
a
show
oral
that-
partition, these properties have been allotted to the
No,
share of the
this-
plaintiff.
This house has been allotted to you.
No, my lords, it was standing in her name. It was, my lords, loan was raised from the bank.
No. How this property is acquired by you? This is a joint family property. In that oral partition, ಈ ಮನೆ ನೀವು ಇಟ್ಕೊಳ್ಳಪ್ಪ, ಇದು ನಾನು ಇಟ್ಕೊಳ್ತೀವಿ, ಅವ್ರು ಇಟ್ಕೊಂಡಿದೀವಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. When that subsequent documents as following that shows that there is an oral partition. That's a matter.
It was not the, my lords, it was not the joint family property.
Where is that contention? It is not a joint family property. It you have purchased. Have you proved that?
That's because we have sought for partition of these two properties. These properties do not whatever
They have come up with a plea saying that no, there is an oral partition. House has been allotted to you. You could have filed a rejoinder saying that no, house is my self-acquired property. It is not allotted in oral partition. It is not a joint family property.
Lordship may kindly see the cross-examination of PW1 in that regard.
ಇಷ್ಟಕ್ಕೆ answer ಹೇಳಿ.
ಅಲ್ಲ ಇದಕ್ಕೆ they have put a suggestion that I will.
Where is your pleading? First, show me that this house is your self-acquired property. ಮತ್ತೆ pleading ಇರ್ಬೇಕಲ್ಲ first.
On the other hand, defendant number 4 specifically taken this contention. This property allotted to the share. There is no rejoinder or there is no answer for that. And in the auction, her own daughter-in-law purchased it. So, what the
That is concerned not may.
ಅಲ್ಲಿ ಚೆನ್ನಾಗಿ ಮಾಡಿದೀರಾ. ಒಂದ್ ತಗೊಂಡ್ಬಿಟ್ಟು ಹರಾಜ್ ಹಾಕ್ಸಿ
ಅಲ್ಲ,
ಡಾಕ್ಟರ್
Melats-
ತಗೊಂಡ್ಬಿಟ್ಟು
That is,
ಅದನ್ನ ಬಿಟ್ಬಿಟ್ಟು ಈ ಮತ್ತೆ ಬೇರೆ ಪಾಠ.
so far as whatever is Melats,
That is why Supreme Court said, otherwise, earlier all partition is a oral. ಅವೆಲ್ಲ ಡಿಸ್ಟರ್ಬ್ ಆಗ್ತವೆ ಅಂತಾನೆ they have also clarified. Subsequent event has to be seen and revenue records has to be seen.
so far as that point
That
is
shows that there was a partition. ಇಲ್ಲ ಅಂದ್ರೆ ಯಾರೋ ಒಬ್ಬರ ಹೆಸರಲ್ಲಿ ಇರುತ್ತೆ ಪ್ರಾಪರ್ಟಿ.
ಹೆಸರಲ್ಲಿ ಇತ್ತು. ಹೆಸರಲ್ಲಿ ಇತ್ತು ಅಂತ ಮಟ್ಟಕ್ಕೆ Melats, it cannot be inferred that there was a oral
ಆಯ್ತ್ರಿ,
partition.
ಎಲ್ಲಾರು ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿಲೂ ಅವ್ರವ್ರ ಹೆಸರು ಪ್ರಾಪರ್ಟೀಸ್ ಇಟ್ಕೋಬಹುದು. ನೀವ್ ಯಾಕೆ ಮಾರಿದ್ರಿ? ನೀವ್ ಹೆಂಗೆ ಯಾವ ರೈಟ್
Loan ತಗೊಂಡು
ನೀವ್ ಹೆಂಗ್ ಲೋನ್ ತಗೊಂಡ್ರಿ?
loan ತಗೊಂಡಿದ್ದು.
ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಪ್ರಾಪರ್ಟೀಸ್
No, Melats, according to us, it was not a joint family property. They say that it's allotted under oral partition. Oral partition ಅಂದ್ರೆ Melats, they must be clearly because other properties are transferred into the name of fourth defendant. It was standing in the,
ಅಲ್ರಿ ಅವ್ರ ಹೆಸರಿಗೆ ಈ ಪ್ರಾಪರ್ಟಿ ನಿಮ್ಮ ಹೆಸರಿಗೆ ಇರೋದು ಇನ್ನೆಂತ ಬೇಕು ಡಾಕ್ಯುಮೆಂಟ್ಸ್. ಅದರ್ಸ್ ಆರ್ ನಾಟ್ ಡಿಸ್ಪ್ಯೂಟಿಂಗ್ ದಟ್.
they are the these are all purchasers. Melats. Defendant is appearing for the purchasers.
ಆಯ್ತು, ನೀವು ನಿಮ್ ಇವರು ನಿಮ್ ಬ್ರದರ್ಸ್ ಯಾರು ಬಂದು ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿದಾರಾ ಇಟ್ ಈಸ್ ಪಾರ್ಟಿಷನ್ ಆಗಿಲ್ಲ ಅಂತ? ಯಾರು ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 4 ಯಾರು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿರೋದು?
Defendant number 4 has contested the proof.
ಮತ್ತೆ ಅವರೇ
She is the Melats sister-in-law.
ಗಂಡ ಸತ್ತೋದ್ಮೇಲೆ ಇನ್ನು ಅವರೇ ಬರ್ಬೇಕಲ್ಲ?
ಅದೇ ಅವರೇ ಬರ್ಬೇಕು.
ಅವರಿಗೆ ಒಂದು ಪ್ರಾಫಿಟ್ ಮೇಲೆ ಮಾತ್ರ ಪಾರ್ಟಿಷನ್.
ಅಲ್ಲ, Melats, so far as that aspect of the matter is concerned, Melats, this I will highlight. Kindly grant 2 days time. So ಅದು ಮಾತ್ರ ನೋಡ್ಬಿಟ್ಟೆ ಹೇಳ್ತೀನಿ. Next week.
The request of
Next week, not any day.
next week. Yes. ಅಷ್ಟೇ. ಅವರು ಗಂಡ ಸತ್ತೋದ್ಮೇಲೆ she is alone. All sisters and brothers are targeting her.
ಬ್ರದರ್ ಇಲ್ಲ ಒಬ್ಬ ಮಗ.
Not that Melats, I will clarify.
Yes.
64 against number 65, SP Rajaram for a friend, BN Anantanarayana.
65. Your appellant or there? Yes. You are the plaintiff or a defendant?
That's true.
ಈ ಕೇಸಿಗೆ ಹೇಳಿ ಫಸ್ಟ್, ಈ ಕೇಸ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಹೇಳಿ.
Please. It is joint family property. Then no point of time that have sold the property. Then the trial court not look into the evidence part in detail. And even without looking into the making a reference to the evidence adduced by the PW1. Mechanically, the trial court has passed an order in granting an injunction in favor of the first defendant. That is the first defendant, not the sisters of the owner of the property. Clear admission is made in the, throughout the evidence, and then that part of the evidence is not with the trial. Subsequent, that is subsequent to the filing of the suit, my lord. The plaintiff before the trial court. Now he is a plaintiff in another suit. He has filed a suit for declaration, injunction, and relief, which is pending before the citizen.
In that you are a party.
I am a party. I am a party where it has been posted for evidence. Now PW1, the evidence is there. And then the prayer start is already answered. There is lordship can see the page number 8 of the document which has been produced in OS number 3991. 39. Page 8.
Date of what?
I have produced the document, blind copies, and then the other things. 9/12/2019. 9/12/2019. Where he has categorically admitted my position, and I have constructed the 2-floor building also. When such is the fact, that is how the suit is maintainable before the trial court only for the parenting.
Where?
Page number 8. The plaintiff OS number 3791 of 2019.
2008.
2019 it has been filed.
So ಇದರಲ್ಲಿ ಫಸ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕ್ಲೈಂಟ್
Right. Page number 8 ಅಲ್ಲಿ OS number 1334 of 2008 in the center of the same has become paint complete, and the said the decree has become infructuous as the defendant 1-4 in collusion have wrongly occupied the suit schedule property during the pendency of the suit.
No, that where you are reading, I didn't get it.
Yes, my lord.
First, you have produced these documents.
9/12/2019.
Huh?
9/12/2019. I have produced the documents about
9/12/2019 ಅಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ?
foreign number.
ಮತ್ತೆ ಯಾವುದೋ ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಕಿದ್ದೀರಲ್ಲ 2017. Uh, 9/12/2019. Yes.
The OS which has been filed before the trial court, where the appeal is pending before the page number 8.
Yes.
It has also stated that is the original suit which has been filed before the trial court, where the injunction order has been granted in our favor. Now issues has been framed in the trial.
ಆಯ್ತು, ಇದು ಫಸ್ಟ್ ತೋರಿಸಿ ಎಲ್ಲಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ನೀವು.
Page number 8 ಅಲ್ಲಿ. Page number 8 ಅಲ್ಲಿ ಕೆಳಗಡೆ ಒಂದು 11ನೇ ಲೈನ್ ಅಲ್ಲಿ. OS number 1334 of 2008. Lordship got it?
Yes.
The same has become paid complete, and the said decree has become infructuous as the dependent 1-4. 1-4 under the dependent number 1 ಇದ್ದಿದ್ದು have the court ಅಲ್ಲಿ. 24 in collision have wrongly occupied the suit schedule property during the pendency of the said suit illegally and have constructed permanent structures on the suit schedule property.
this is an admission.
No, now the suit is filed for recovery.
No, it is for possession.
Ade,
Now
ade.
it is
Suit for possession.
Declaration, possession. That is declaration of the title to the scheduled property. So if he has accepted that she is not in possession of the property.
No, she said, after that you have come and encroached that during the pendency.
No, not like that. That is the defense has been taken by
The same become,
ಏನಾಗಿದೆ
the
ಅಂದ್ರೆ,
same degree become infructuous as owner for possession have wrongly occupied the suit scheduled property during the pendency of the said.
ಅಲ್ಲ, ಅವರ appointment
Legally, they have, yes,
constructed permanent.
1334 of 2008.
The plaintiff submitted by virtue of the documents created with the
ಆಯ್ತು, ಯಾರು ನಿಮ್ದು ಎದುರುಗಡೆ ಯಾರು?
Huh?
Who is that?
opposite.
ಇದನ್ನೇ ನೀವು ಮೊನ್ನೆ ಹೇಳಿದ್ದು.
ಏನು? Right.
ವೇರ್ ಇಸ್ ದಟ್ ಅನಂತ್ ನಾರಾಯಣ್? ನಂಬರ್ ಎಷ್ಟಿದೆ?
The subject matter is whether the suit filed by them for injunction is by the document 1 to 8. Those documents that they have not proved. Even then, the trial court has come to the conclusion. Again, it is not the owner of the property. Their giant family was the owner of the property, and his sister was the owner of the property to the surveillance, that is site number. So all these aspects have been ignored by the trial.
ಆಯ್ತು, ಇಗ್ನೋರ್ ಅಲ್ರಿ, ಇದು ಆಮೇಲೆ ಹೇಳಿರೋದು. ಡಿಗ್ರಿ ಬಿಕಮ್ ಇನ್ಫ್ರಕ್ಚುಯಸ್ ಅಂತ ಅವ್ರು ಹೇಳ್ಬಿಟ್ಟಾರಲ್ಲ. They said degree become infructuous. Where is that? Where is it?
We have proved, that is the defendant has proved that they are in possession of the property. Now the litigation is there and pending, and then it has to be decided regarding the title to the property.
Then why the trial court held that you are not in the position? Where is the finding?
Evidence is evidence.
Finding evidence ಅಲ್ಲಿ ಏನು ಒಪ್ಕೊಂಡಿದ್ದಾರೆ ಅವರು?
Evidence I have produced on 2/8. The document I have produced.
ಯಾವ್ದ್ರದ್ದು ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ? ಆ ಹೊಸ ಸುಟ್ಟಲ್ಲ?
Evidence, there is evidence of
PW1. ಏನ್ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ?
Exhibit P1 and P9 produce ಮಾಡ್ತಾರೆ.
ಎಲ್ಲಿ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ?
Page number 12, not significantly in the last. But it is true to suggest that I have not produced any document to show that it is within the limit of. If there is no document with me, it is true to suggest that there is no document in any other office to show that the Khata number 130 part and parcel of the property is surveyed. So the claim of the plaintiff is, this is a part and parcel of the survey. This is the transaction. First, please you look. There is a page number 15, my lord, second paragraph. I purchased the property, page number 15.
Page number 15.
Page number 15, second paragraph. And I purchased the property for the first time. I saw the good property. Not using it. Now, witness volunteered that her husband visits the two scheduled property offer. It is true to suggest that there is no document that in the name of. It is true to suggest that in the year 2007, 2008, and 2009, I had not been in possession of the two property.
It true to suggest that prior to 2007 and after, although I have not been in possession. Categorically, that.
Then why the trial court has granted an
I do
injunction?
not know.
Where is the finding? Where is the finding?
The finding of the trial court, that is only one point. You into them to. That is page number 10, page number 10 of the judgment. Page number 10 of the judgment.
Now that you have filed in a separate suit. Now that this has to go, then in that plaint itself, you have said this degree has become, somewhat in.
Judgment and degree as part of influences.
Influences and you yourself. But without influencing any order of this court, let him decide independently. I will set aside and say that by set asiding will not come in the trial court to decide. Deciding in accordance with yes. And this appeal is filed by challenging judgment and degree dated 19th September 2016, passed by 44 additional cities, civil and section judge Bangalore in OS number 1334 of 2008. By suit filed by the plaintiff is decreed. For the sake of the convenience, parties are referred to the ranking as per the trial court. The plaintiff, the case of the plaintiff that plaintiff is the owner of the suit scheduled property. Since defendant, without any right or title over the property, has tried to interfere to the possession of the plaintiff, plaintiff has filed the suit for bare injunction. After service of summons, defendant appeared through their counsel has denied the plaintiff government, contended that the defendant is in the possession of the suit scheduled property. After considering that evidence of the parties, trial court has decreed the suit granted an perpetual injunction in respect of suit scheduled property against the defendant. Be agreed by the same. Defendant has filed this appeal. During pendency of this appeal, the plaintiff has filed comprehensive suit for declaration, possession, and injunction. The other consequential relief in OS number 3791 of 2019. The respondent appellant, the defendant appellant has filed a memo before this court on 9/12/2019 has produced that plain copy in OS number 3791 of 2019 filed by the plaintiff in City Civil Judge Bangalore. In the plaint, it is specifically pleaded that the plaintiff has obtained the degree in OS number 1334 of 2008. The said degree become infructuous as the defendant number 1 to 4 collusion have wrongfully occupied that suit scheduled property during the pendency of the said suit illegally and have constructed the permanent structure on the suit scheduled property. Therefore, now the plaintiff has filed comprehensive suit for declaration and possession. ಯಾವ್ದ್ರಲ್ಲಿ? Yes, I in view of the plaintiff has filed a comprehensive suit and admitted the position of the defendant appellant. The decree passed by the trial court dated 19 September 2016 liable to be set aside, passed in OS number so and so is liable to be set aside. Accordingly, the appeal is allowed. The judgment and degree passed by the trial court dated so and so is set aside. It is made clear that any observation made by this court will not come in the way of the trial court to decide that comprehensive suit filed by the plaintiff in OS number so and so in accordance with. Yes. All pending applications are disposed.
Proceedings, HP Leela for appellant, Kumar.
Yes, Leela.
Respondent hearing has filed a suit in case number 347. We defendant in that suit also filed a suit in case number 39461.
I will continue to the next week. Yes. At the request of.
Injunction suit maintainable. They themselves admitted at the time of filing suit. I am in possession of them.
ಯಾವ್ದ್ರಲ್ಲಿ?
Our suit
No, that who has filed this suits in
one suit is filed by the respondent hearing with the plaintiff in OS number 3247/2006.
3247 of 2006.
ಅಲ್ಲೇ admit ಮಾಡ್ಕೊಂಡು.
No, that is filed by your client.
Defendant in my suit.
Defendant in your suit. They have filed a suit for injunction.
Yeah, my also myself also filed a suit in OS number 39461.
Nimdond injunction suit or in respect of the same.
They are in position.
But trial court has dismissed your suit and declared. Where is the finding of that trial court regarding that they are in the position?
Yes.
And where is that admission?
Admission.
Our admit ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ನೀವು.
ಅಲ್ಲ 5 ತಗೊಳ್ಳಿ 5 ಬುಕ್ಕಲ್ಲಿ OS ನಂಬರ್ 493 ತಗೊಳ್ಳಿ RP ನಂಬರ್ 493 ತಗೊಳ್ಳಿ
ಎರಡು ಬೇರೆ ಬೇರೆ ಪೇಪರ್
ಬೇರೆ ಹಾಕಿ
ಯಾಕೆ ಒಂದೇ ಎವಿಡೆನ್ಸ್ ಇಲ್ವಾ?
ಮುಂದೆ ಎವಿಡೆನ್ಸ್ ಮುಂದೆ
ಮತ್ತೆ ಯಾಕೆ ಪೇಪರ್
ರೈಸ್ ಮಾಡ್ತೀವಿ ಎರಡು
ಅಲ್ಲ ಒಂದು we have to seek for dispensation.
ಅಷ್ಟೇ ಅದು ಕೇಳ್ಬೋದು. Number 8, internal page 5.
Internal page 5.
Yes. Authorities failed to take consideration of the act. It's a complaint. Defendant started excavating for the purpose of putting up approaching the property of the plaintiff on the west.
ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿರೋದು ಅವ್ರಿಗೆ.
ಹೌದು.
17/4/2006.
ಹೌದು.
ಸೂಟ್ ಯಾವಾಗ ಹಾಕಿದ್ದು?
45. 4 days.
Now you are trying to encroaching the property. They have not admitted that you are in the position.
The defendant started excavating for the purpose of construction by encroaching the property of the plaintiff on the western side and eastern side of the property. The plaintiff.
ನೀವು ಅಟೆಂಪ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಅಂತ ಅಡ್ಮಿಟ್ ಮಾಡ್ತಾರೆ. ಲೆಟ್ ಅಸ್ ಸಿ.
ಸರಿ, ಫೋಟೋ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ, ಅವರೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ. ಕಮಿಷನರ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡಿದ್ರೆ ಅವರೇ ಹೇಳಿದ್ದಾರೆ 1 ವರ್ಷದಿಂದ ನಾನು ಕಟ್ತಾ ಇದ್ದೀನಿ.
Then why the trial court has
ನಾವು ಆಡ್ ಘಟನೆ ನೀವು ವೈಲೇಟ್ ಮಾಡಿದ್ದೀರಿ. ಅದ್ರ ಬಗ್ಗೆ ಎಲ್ಲಿ ಮೆಟೀರಿಯಲ್ಸ್ ಕಾಂಪ್ರಮೈಸಸ್ ಫೈಲ್ ಮಾಡಬೇಕಾಗಿತ್ತು. ಈಗ ಸಿಂಪಲ್ ಸೂಪರ್ ಇಂಜೆಕ್ಷನ್.
Yes. Yes, at the request of respondent, leave this matter next week.
Number 68, Bhavana TK for appellant, Ravi HK.
Yes. Yes, Mr.
Number 68,
Injunction suit, 230.
Actually,
Next week. Yes, at the request of the parties, leave this matter next week.
number 69, Abhi Deshpande for appellant, Vijay Narayan Sharma.
I appear for the respondent 69.
Yes, 230. 230.
My learner foot is there, my lord.
He is seeking time. He is there. He is taking time. No, you can see that in the screen. Other sides appearing.
Either ಇದೆ. I could.
You can see. That's what we have. That's arrangement we have made.
Correct.
Know that the other side is.
In this court hall, it is there, my lord. Some other court, some. Anyway,
Yes.
he
He
is
wants
seeking-
time, Mr. Narayan.
ಏನು ಆಯ್ತು ಕೆಲವು ಸಲ ಆಯ್ತು ಎನಿವೆ ಅವ್ರಿಗೆ ಟೈಮ್ ಬೇಕು ಅಂದ್ರೆ ಐ ಕಾಂಟ್ ಪ್ರೆಷರೈಸ್ ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಡಿ ಯಾಕಂದ್ರೆ ದ ಪ್ರಾಪರ್ಟಿ ಈಸ್ ಎಂಜಾಯಿಂಗ್ ಆನ್ ಮೈ ಪ್ರಾಪರ್ಟಿ ದ ಫೈಂಡಿಂಗ್ ಇಸ್ ಇನ್ ಮೈ ಫೇವರ್ ಡಿಮಾಲಿಷ್ ಅಂಡ್ ಗಿವ್ ದ ಪೊಸಿಷನ್ ಅದಕ್ಕಾಗಿ ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಡಿ ಇವತ್ತಿಗೆ ಆಗದಿದ್ರೆ ಶಾರ್ಟ್
Next
ಡೇಟ್
week.
ಕೊಡಿ
Yes.
Number 49, for the respondent, the other side is not turned up. Some income is should kindly Monday.
40.
9th one, ಅದರಲ್ಲಿ ಅವರೇ ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಪೊಸಿಷನ್ ಇಲ್ಲಿ ಇಲ್ಲ. ಅವ್ರು ಅದರ್ ಸೈಡ್ ಬದಲಿಲ್ಲ. Some income Monday action.
Next week.
Please, ma'am.
Yes. At the request of the parties, leave this matter next week.
Bill number 8.
230. Why it is? Huh?
Please objection.
Why you not complained?
Council.
Degree, what has happened, Mr.?
Money request.
Yes, at the request, finally 2 weeks to complete absence.
Right.
ನಿಮ್ಮ ಕೋರ್ಟಲ್ಲಿ ಚೆನ್ನಾಗಿ ಬಂದಿದೆ ಬೇರೆ ಕೋರ್ಟ್ಗಳೆಲ್ಲ ಸರಿಯಾಗಿ ಜಸ್ಟ್ ಮಾಡಿಲ್ಲ ಕೋರ್ಟ್ ಹಾಲ್ ಅಪಿಯರೆನ್ಸ್ ಅಲ್ಲ ಎಲ್ಲ ಚೆನ್ನಾಗಿ ಆಗಿದೆ ಈಗ
ತಪ್ಪೆಲ್ಲ ಒಬ್ಬರು
Bill number 40. ಬೆಳಿಗ್ಗೆ ಗೊತ್ತಿತ್ತು ಸರ್ ಏನು ವಾರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದ್ದಾರೆ
ಆನ್ಸರ್ ಮಾಡಿ
44 ಏನು ವಾರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ ಸರ್ 44
ಚೀಟಿ ಬಂದಿದೆ ನನಗೆ ಟೈಪ್ ಮಾಡಿ ರಿಪೋರ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಟೈಪ್ ಮಾಡಿ
ನಾವು ಕರೆದಿದ್ದರೆ ಸೇವ್ ಮಾಡಿ
ಏನ್ ಹೇಳ್ತೀರ ಬಿಡಿ ಇರಬೇಕು
ನಾನು ಸರ್ಟಿಫಿಕೇಟ್ ಕಾಪಿ ಪ್ರಯತ್ನ ಮಾಡ್ತಿದ್ದೆ
ಆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಶುಕ್ರವಾರ ಈ ಕೋರ್ಟ್
Okay, YouTube.
Purification is allowed. Order dated so and so in RFA is recalled. RFA is restored to the file. All pending applications are disposed. Okay. RFA connected ಅಲ್ಲ. ಹೇಳಿದ್ರು ಸರ್ ಮೇಡಮ್. ನೋಡಿ ಸರ್. ಇದಕ್ಕೆ ಚೆಕ್ ಮಾಡ್ಬಿಡಿ. ಹಾ ಸರ್.
Number 1, serial number 2, CH Dwarakanath for appellant. Number 1, serial number 2, CH Dwarakanath.
ಬರೀತಾರೆ ಏನು ಮಾಡಿಲ್ಲ. Limitation para to be stated correctly. Very
application ಹಾಕಿದ್ದು ಹೇಳಿದ್ದೀನಿ.
ಇಲ್ಲಿ ಮೆಮೊದಲ್ಲಿ ಲಿಮಿಟೇಷನ್ para ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿ ಅಂತ.
ಇದು ಮಾರ್ಜಿನಲ್ ಡಿಲೇ ಆಫ್ 28.
ಮತ್ತೆ ಅವರು ಲಿಮಿಟೇಷನ್ para ಬರುತ್ತೆ. ಮಾಡಿದ್ದಾರೆ ಸರ್. Limitation. Regular appeal is in time. Correctly to be stated ಅಂತ our objection. Is it in time? Yes, sir. Delay application ಇದೆ. Delay ಇದೆಯಾ?
25 ದಿವಸ ಇದೆ.
ಮತ್ತೆ why this appeal is in time ಅಂತ ಹಾಕಿದ್ದೀರಾ? That limitation paragraph in that 11. That is what the topic of they said. If it is in time, that application is not necessary.
28 days delay ಇದೆ ಅಂತ application.
That is preferring of it, necessary application has been filed to delay. Hence, registry it is ಮತ್ತೆ ಇನ್ನೊಂದು ಏನಿದೆ?
Your time.
Full cost list to be furnished at IA for
ಒಳ್ಳೆ application ಅಲ್ಲಿ ಅಂತ ಹೇಳಿ. Okay.
address of the respondent number 2 and the appellant to be
Partially.
correctly as cost title in the favor appeal. Address of the respondent number 2.
ಸರಿ ಇಲ್ಲ ಅಲೆಂಟ್ ಸರಿ ಇಲ್ಲ ಸರ್ ನಂಬರ್ 2 ಕರೆಕ್ಟ್ ಮಾಡಿ.
Address of the respondent number 2 and the appellant to be
ಸ್ಟೇಟೆಡ್ ಅಂತ ಇರೋದು ಅದು ಸ್ಟಿಚ್ಡ್ ಅಂದ್ಬಿಟ್ಟು ಇಟ್ ಟು ಬಿ ಕರೆಕ್ಟ್ ಇದೆ. ಅಪ್ಪಲ್ ನಂಬರ್ 2 ಕರೆಕ್ಟ್ ಇದೆ.
ಅವ್ರ appellant address ತೋರ್ಸೋದಕ್ಕೇನು ಅವ್ರದ್ದು ಹೆಂಗಿರುತ್ತೋ ಅದು ತೋರಿಸ್ತಾರೆ. ಹಿಂಗೆ ತೋರ್ಸ್ಬೇಕಂತೇನೆ. Current address Linear Communication Private Limited correct? Limited. Case number of the trial court to be stated correctly in the prior of the appeal. 4.6.
ಆನ್ಲೈನ್ ಅಂತಾರೆ ಅದು ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ನಾವು ಹಾಕ್ಬೇಕಿತ್ತು.
Valuation cannot to be stated incorrectly. ಎಲ್ಲಿ ಕಟ್ಟಿದ್ದೀರಾ ಕೋರ್ಟ್ ಫೀ? ಎಲ್ಲಿದೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್? 2,668 to be paid. Very that. ಅದಕ್ಕೆ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಬರಲ್ವಾ ಆನ್ಲೈನ್ ಪೇಮೆಂಟ್ಗೆ? ಬರಲ್ಲ ನಿಮಗೆ ಇದು ಬರುತ್ತಲ್ಲ. Now that today you have paid that 2,660. Yes. What is this? What is the delay? Yes. What is this matter? Give it. Give it. Yes.
Victoria money has been filed by the plaintiff. 3,26,000. Amount is very small. I am dependent to show a ball name is shown. Is a ball name is a brand name of mine. Information technology part. ITP is a sentence form. I appeal to the trial court said it's not a legal entity. Name of the ball.
ಯಾವುದು?
Ascent is the appellative first.
Ascent
Cost item.
or Square Mall.
It's the ball itself.
Huh.
Legal entity is a information technology part. So the suit is not maintainable. Again, the product name of the ITP. Some notice issue.
Yeah, no, what is your relationship and this thing? What is the transaction actually?
And the radio transaction ನಾನು ಡಿಪೆಂಡಬಲ್ ಒಂದಿಗೆ ರೇಡಿಯೋನಲ್ಲಿ ಪಬ್ಲಿಕೇಶನ್ ಮಾಡುವ SMS ಮಾಲಿಂದು ಅಂತ ಕೊಟ್ಟೆ ಮಾಡಿ ನಾನು ಪೇಮೆಂಟ್ ಮಾಡಿ ಅವರು ಪೇಮೆಂಟ್ ಕ್ಲಿಕ್ ಮಾಡಿ ನನ್ನನ್ನು ಮಾಡಿ
ಪ್ಲೈಂಟಿಫಿಗೂ ಅವರಿಗೂ ಏನ್ ಸಂಬಂಧ? ಪ್ಲೈಂಟಿಫ್ ಇಸ್ ದಟ್ ಹೂ ಇಸ್
ರೇಡಿಯೋ ಹೌಸ್
ಅವ್ರದ್ದು ರೇಡಿಯೋ ಹೌಸ್
ನಂಬರ್ 1
ಅವ್ರು ಯಾರು?
ಅವ್ರು ಪಬ್ಲಿಷ್ ಮಾಡಿ ಅವ್ರ ರೇಡಿಯೋ
ಕಮ್ಯುನಿಕೇಶನ್ ಪ್ರೈವೇಟ್ ಲಿಮಿಟೆಡ್ ಅವ್ರ ಏಜೆಂಟ್ಸ್ ಅವರು
ಅವ್ರದ್ದು ಏಜೆಂಟ್
ನಿಮ್ಮಿಂದ ಮಾಡಿರೋದು ದುಡ್ಡು ಕೊಟ್ಟಿಲ್ವಾ ನೀವು? ಮತ್ತೆ ಅವ್ನು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ.
ನಾನು ಅದನ್ನೇ ಹೇಳ್ತೇನೆ ನಾವು ಪೇಮೆಂಟ್ ಮಾಡ್ತೀವಿ.
Is there any contract between plaintiff and you?
Judgment no contract finding ಇದೆ.
Then they have to claim against that defendant number 1. Is there any is there any degree against that defendant number 1? Plaintiff is entitled to recover so and so defendants. Then I will stay only in respect of yours. Counsel for the appellant has submitted that office objection has been complied and deficit of court fee of 2,668 has been paid. Today, online. Submission is taken on record. Even though there is a delay in filing that appeal, peculiar facts and circumstances of the case, in consideration of delay application, issue notice, stay of judgment and degree dated 25th September 2023, OS number 2476 of 2016, passed by 41st Additional City Civil Judge, Civil and Session Judge, Bangalore, in respect of appellant is concerned. Stay only in respect of appellant. Yes.
5 N Kumar for appellant. Serial number 5 N Kumar. Number 7, ULP for appellant. Serial number 7.
This person.
Serial number 9. Rudikara LV for appellant. Serial number 9.
Of granting 4 times. Office objection is not complied. The matter is called in morning session. None appear for the appellant. Afternoon session, no representation on behalf of the appellant. Leave this matter tomorrow. Top of the list for orders under the caption for dismissal.
Number 11, V. Siddesh for appellant. Number 11, V. Siddesh.
matter is called twice. None appears in spite of granting 5 times to complete the office objection. Office objection is not complete. Hold this matter tomorrow. Top of the list for orders.
Number 28, Ramchandra Srinivasan, 50 for appellant. Number 28.
None appear for the appellant. Each time is granted. To do the meeting.
A50 for appellant, A Narayana. Number 29.
Yes, week's time is granted to do the meeting.
Number 32, Deshpande Amit Anand for appellant.
Midland Council for the appellant submits that needful has been done. Office to verify and proceed further.
Number 44, Narayana Mimma for appellant, P.D. Surana.
Yes. Yes, Mr. Prince. Yes, dismissal of the appeal along with the statement of objection. Yes, what is this matter, Mr.?
They apply. Apply every. He was provided with a house to reside. He has resigned in October 2016. Instead of vacating the house, he has filed a suit.
Yes.
Court has said that you are a licensee, you have no right to maintain a suit. You have to, and reasonable time is granted to remove himself.
Yes, Mr. Prince.
Did not claim when the time is. Who claim for possession? Where the transport loading. It's for not bring such a. It's not accidental. It's not there in the buildings of that is because he has filed another complaint under the Complaints Act. Asking for the vacation of the same premises. It was twice. He has filed yet another two. While praying for portion of the property, praying for the damages for the property.
No, you are an employee.
I am not an employee for him. What he says is there are two persons. One is the Abadal, and he owns a company called PM Exports Private Limited. He said that he has given and leased the premises to PM Exports Private Limited. Therefore, as of today, he only constructive portion of the premises, and the PM Exports Private Limited is the incorporated company, which is that company has filed a complaint against me under 452 of the Companies Act. That matter is pending before this court in criminal petition, asking for the person is very same property. So my lord, and another proof of filed for 2260 of 2018. In that case, for the very same property, he has not asked for possession because 232 of 17 was there.
No, first, what is your right to be there in that property?
He has given me as a terminal benefit. He has agreed to transfer the property to me. That is one pending. Second thing is, as on this day, all these days I have believed that it is his property. Now I understand it is not his property at all. He says he has purchased the property. His father has purchased the property. And in spite of asking him to produce the purchase deed, sale deed, he has not produced the sale deed. All he gives is only the revenue records. Therefore, listen. And in the absence of plea, my lord, the Supreme Court clearly says there cannot be a degree.
Yes. Now you give the facts of your case. Yes. Where is that line? Paper book is filed.
Where to file? My lord, I have filed another application for seeking for permission to file additional documents. That has not.
Yes, now there is an application for vacating. I will vacate that interim order. Then there is no interim order. You don't want to execute it.
No, my lord, there is an interim order is continuing.
Kindly give the order sheet dated 18/8/23. Mistake I put there. 18/8/23 ನಲ್ಲಿ interim order granted earlier, it has been extended again.
Yes. After that, it is not extended.
It is not extended.
Yes, from 7/9/2023,
Yes.
there is no interim order. Almost 4-5 months. Yes. You want to execute that?
There is an interim order.
Where is show me that order sheet is before me? Admittedly, you are not the owner of the property. You are either a lessee, licensee, tenant. You have to vacate. Yes, that's what. Now argue that.
Ready to argue. In the meantime, you are not saying that the opinion that there is no interim order. The interim order dated 28/11/23 due to positive time release. In the meantime, without prejudice to the rights and contents of the client. Why the making it subject to further orders of this court, and final order is apparently that about in the meantime, stay is corrected. Therefore, my lord, I mean, deposit, even the deposit has been asked to make.
When that interim order is granted,
Extended last was made on that day.
yes, interim order is, you see that 18/8/2023.
88. The respondents, the case adjourned for a week, interim order granted earlier till the next date of meeting. After that, my lord, he has been permitted to file the objection for vacating this day.
Whatever may be this, whether interim order is extended, that's what I'm asking.
Clear order itself also.
No, that has been modified by order dated 18/8/2023. Interim order granted is extended till next date.
28/11/23. 28/11/23.
28/11/23 ಯಾಕೆ ಬಂದ್ರಿ ಅಲ್ಲೇ
ಆಗಿಲ್ಲ, ಅದು ಆಗಿಲ್ಲ.
28
Prejudice to the rights and the contents of the claim, the claim of the party, making it subject to the order of the board, outcome of subject, we have been asked to pay deposit. Otherwise,
28/11.
There is no
In the meanwhile, without prejudice the right and contest claim, the parties in so and so making it OS and making it subject to the further order of the court, final outcome of this appeal, appellant is directed to deposit ಅಷ್ಟೇ.
Yes, I have deposit.
But interim order ಕೊಟ್ಟಿಲ್ಲ.
There is no interim order. Where is the idea for filing for vacating interim order?
Infructuous ಆಗುತ್ತೆ ಬಿಡಿ. Infructuous, it will become infructuous. If they filed an application that doesn't, suppose this court is not granted any interim order, somebody is filed and vacating, that doesn't mean that there is a.
Into the order sheet clearly says that the interim order has been granted.
That is your understanding.
Not.
Yes. If that is the case, yes. If his interim order is there in your favor, yes, you take it that advantage. If it is not there, you will take that advantage. Yes. Then we will have it after 2 weeks.
I final argument now itself.
No, you want time, you said it.
Time. I am prepared to make my submission on the pen on the.
Yes. What is your case? In the plain. Has he admitted that you are the owner? Plain page. Yes.
Therefore, Supreme Court has said, Supreme Court has said that in case of licensing, this kind of right should be granted to the class.
Yes, Mister. Yes. Yes, let him argue. Yes. Yes.
Respondent defendant to the statement did not make any conflict for the delivery of the personal social property, not make any claim for damages, personal profit, or wrongful use of social property. It's a 35 of the paper. Therefore, it is great that the Honorable Court will be pleased to dismiss the above petition, the above suit with the exemplary cause and with the different interest of great justice. They are not asking for the.
Where you are reading?
Page number 35 of the paper, last page, where 32, where the
Page number
35, paper book.
Yes.
Last term. Therefore, it is great that the Honorable Court will be pleased to dispute the above suit with the exemplary cause and the different interest of great justice. Therefore, they are only asking for the dismissal of the suit, not for the purchase of the property. No issues were for it. Kindly 410 of the paper.
Yes. Issue regarding?
Regarding the whether I am a license, whether it is entered for purchase, whether for damages. 410.
Yes.
Whether the plaintiff quoted in
Yes.
whether the plaintiff proved his lawful possession of structured property. Whether the plaintiff interference of the defendant in structured property. Whether the defendant proved the structured property is identifiable as given in the plea.
Yes.
Whether the plaintiff is entitled to for relief sought for. Whether what order and degree. There is no regarding whether the defendant can, whether the plaintiff with the license or what is the license amount, what is the damage. This, with the actions of the media and defendant, the Supreme Court has clearly said, no relief granted, I'll come to that later. Before that, perhaps endeavor should be commission. It's not accident. It's intention. They are claiming the same relief in different forms, in different persons. Even as early as 123, 22, 380.
Now that, what is the reason given by the trial court now? You come to that. Reason.
See, the trial court has not given any reason. He said, I'm not the owner, therefore I'm liable to throw out. And police can.
No, taking that finding of the trial court.
I make my submission. I make my submission. I'll submit this week. After that, we go to the trial court order also. Because what I. 5-10 minutes, I'll submit my case, what is my defense. Then I'll take your what.
No, it is, see, understood, it is not necessary going to all this. Now your case is that you are sued for injunction. What is the requirement is, you have to be there in the possession as on the day of filing the suit.
Yes. That is not in dispute. But he says, I am in, what is this?
No, that's what your case, when they are admitted, you are in the possession. Why the trial court has not granted the injunction, whether licensee or that you are in the possession of, what is your position in that property? You are not an owner. Your position is as a licensee. Can the licensee seek for any injunction? That is the point that has to be considered, is it not?
And I can be thrown out by the law. But
That is what, yes, Mr. Let him. Now that.
If I am a licensee, and if the part of the license if you file a suit for indictment on the basis of I am a licensee, he should seek for it. Suppose you are not thought. I file a suit for.
No, see. He has not come you to throw a court that he has forced. Force of law.
That is what I am trying to say. I am not going to say no anything else. I cannot say that I am a licensee, I will not be a perfect licensee. In the absence of any question against me, for evicting me, I cannot be thrown out. That is what my case before the plaintiff also. And I have said very clearly.
Water. No, this is settled law. Now that what is that? Can that licensee file in a suit for injunction?
Licensee is not filing a suit for injunction in the capacity of in the capacity of possession of the property. I am saying that don't out except by this of law. Please file a terminate my license, file a suit, throw me out. What my learned friend has quoted, so many Supreme Court cases. All these cases are under 142. case. And all these cases, they have taken that the other side is the licensee. That in my case, in the plate,
Even if there is a licensee, can be thrown out without due process?
that's what exactly I am.
Now that we'll see that Supreme Court judgments, that's all. No, that is the legal points. I need not go all these things. If you show that license can be thrown out without any notice. ಅಲ್ಲಲ್ಲ ಈ ಪಾಯಿಂಟಿಗೆ ಆನ್ಸರ್ ಮಾಡಿ ಐ ಸಿ ಡೋಂಟ್ ವಾಂಟ್ ಟು ವೇಸ್ಟ್ ದ ಟೈಮ್ ಫೈನಲಿ ಕಮ್ ಟು ದಿಸ್ ದಟ್ ಈಸ್ ವಾಟ್ ದಟ್ ಆಯ್ತು ಯಾವ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡಿ ನಿಮ್ಗೆ ಅಲ್ಲ ಅವ್ರದ್ದು ಯಾವ್ದೋ ಜಡ್ಜ್ಮೆಂಟ್ ಲೆಟ್ ಅಸ್ ಸಿ ದಟ್
this case, ownership over a piece of land, 1 feet by 17 feet, and there was no plea for that. I want the easement right. In the absence of easement right, only what is the area? 1 feet by 17 feet. The Supreme Court said nothing doing.
This is for the properties is concerned.
No, plead without pleading. In the absence of a pleading, in the absence of pleading, in the absence of prayer, what cannot grant relief?
That I see. That I will come to that.
My lord.
I understood what you said. No, I understood, Mr. What you said. See, if the law says even licensee cannot be evicted without due course of law, then in your suit, it cannot be a relief for him to evict him. That is what you are saying that. He is saying that there need not be anything. Let me see what is this case. If that is the law, what Supreme Court said, he can be thrown out without any notice. See, suppose if the judgment which shows that, yes, he can be evicted only due course of law, then we will come to see that if there is no pleading, then court grants such a relief. Let him show that first. Let him show what is that judgment which says licensee can be thrown out. Yes, Mr. Yes, you have given a copy to him. Yes. Which judgment you are first? That is 2022. Live law 61. You start from page.
What is
34. You said 62. 74. This is our High Court judgment.
Yes.
Yes. Yes. Yes.
So like the corporation, we give for now this position and second position as much something developed. This may be very legal position all along the way with that. So the not question very created the we state itself provided does not use more than necessary. But the entry would be received only at the danger of the department for in case of equally, it's also equally settled. The position right in front of information within the government. Licensing not impact any use. Exchange license and everything the licensee does not have to do with the position. The position always makes the right. So this is the which is the access and small shop in the market is the authority and status of the licensee. The license regulator, the position not the market. Effective. We can call it. The licensee and that will be and the legal property of the policy that will allow to pay. So continuing to leave the property at the airline and remove any rules which are the low in place of the problem. Coming to the other case, license, India, review the election. Legal version
Yes, this is the law as on today.
Then the delay will be next step at 388.
Yes, I saw that. Yes. Again?
What is?
Hey, Chester? Yes. That is again our High Court.
And what was the effect of the legal with the expert? In the aforementioned period, and then you do the decision paper. The government is not only to use it, they would respond to not only and of the therefore the question of the authority measures.
Yes.
One of the matter of the remove the residence cannot be protected in the light of the always
Yes. Yes, what you say about this level? Where is that Supreme Court? We'll have it tomorrow. 2:30 we have reference today. 3:30. No, that is not that. If it is a licensee, this court said that only remedy is to take some time and leave case.
That's what the director has done. That's what the director has done. The director has done. And you retire from time later, time is given to you.
Whether I am a licensee, in the case of a licensee, the licensor permits him to do a certain job subject to control of the licensor. Here I am living in a rented house. There is no control. All the cases are shops. All the cases are rooms in a hotel, where the ultimate control is with the licensor. He cannot work. The case is
Come to the house also.
no, nothing. As far as even assuming that, can this fact, whether I am a licensed or a licensee, can be decided without there being a plea, without there being a trial. And not only that, then this is the case of him. Why is that he has not seen the same relief in some other case where he has filed for the same relief? No, harm come.
This is for him to.
No, this court should know. What I am trying to say, I will appeal to this court. This court should always discredit a person who is jumping from one court one forum to another court simultaneously.
No, it is not under 226. It is, if it is a 226, my power is different. Here, suit, I have to see within the pleadings.
No.
We can't go beyond that.
No, within the pleadings, if your lordship says, here, no case. That's what I'm saying.
Tomorrow. Read this matter tomorrow. Morning order, illa. Morning order I have not done. That I have not signed and they said.
Tomorrow I will.
Yes, tomorrow.
45, 30 pages for apparent. 45. ನೋಟಿಸ್ ಇಶ್ಯೂ ಆಗಿದೆ ಸರ್ವಿಸ್ ರಿಪೋರ್ಟ್ ಏನು ಅಂತ ಕೇಳಿದ್ರು ಪಿಕಪ್ ಮಾಡಿಸಿದ್ವಿ ಸರ್ ಇನ್ನು ಅವಾಯ್ಡ್ ಸರ್ವಿಸ್ ಅಂತ ಬಂದಿದೆ ನಮ್ಮ 3 ಜನಕ್ಕೆ ಬಂದಿದೆ 2 ತೀರೋಗಿದ್ದಾರೆ ಸ್ಟೆಪ್ಸ್ ಕೇಳ್ತಾರೆ
Yes. As office note says, service of notice is awaited for responding number. Awaiting service 1 to 8. 1 to 8 and 10 to 14 and 17 to 19. In respect of respondent number 10 and 9 is concerned, there is a report that Hence, 2 weeks, 4 weeks time, 2 weeks time is granted to take steps in respect of respondent number 10, 9 and 10. Yes. Serial number 2. Appears for the appellant. Is this matter? Next. So, Yan Kumar for appellant. Serial number 5. Unappear for the appellant. Each time is granted to comply the obstacles. Serial number 7. Immediately for appellant. Appear for the appellant. Each time is granted to comply the obstacles. Forty-five.
It's already issued.
No, service is sufficient, awaiting for some respondents. 2 respondents are dead. You have to take steps. You 3,595 ದಿನ ಬಿಟ್ಟು ಅಪೀಲ್ ಹಾಕಿದ್ರೆ ಅವ್ರು ಬದುಕಿರ್ತಾರೇನ್ರಿ ಎಲ್ಲ ಇದ್ದಾರಲ್ಲ ಅವ್ರಿಗೆ ಸರ್ವಿಸ್ ನೀವು ಎಲ್ಲ ಹರಿಸ್ತಾರ ಅಷ್ಟೊತ್ತಿಗೆ ನಿಮ್ ಕೇಸಿಗೆ 10 ವರ್ಷ ಆಗೋದು.